Good morning, everybody.
Morning.
Welcome. The sun seems to have come out today, which is a good thing.
It's a positive sign.
It is. We're passing around the sign-in sheets.
Okay.
So before we leave the table, we'll make sure that everybody gets each side gets a copy of that. On the next meetings, we've got March 5th, which is Thursday of next week set, and that was already posted. That's the deadline for all initial proposals. With regard to availability, our team is available on those dates that we've talked about, which is March 11th on a Wednesday, Thursday, March 26th, Thursday, April 2nd, and Thursday, April 9th. We're waiting on confirmation from Del Mar, this facility, just to make sure that they have room for us. If not, that way we need to figure out what the location, a location.
Okay, I have one, while we're on the scheduling, I have one request. The meeting that we have scheduled for April the 9th, I would like to ask if it's possible to consider moving that to April the 8th, which is the day before. I've been called to court in Lubbock on April the 10th, and I was checking the flights from here to there, and it's pretty hard to get up there.
Yeah, I understand. I've had to do that before. Okay, we'll look at the, I need to.
Hopefully because it's still 6 weeks away, or of course we could be done by then.
Right. Yeah, and the 60 days, I calculated it, and it falls on that Friday, April 10th. Of course, we pursuant to our Rule 11 agreement, we have the ability to extend, to continue negotiating. There's a lot of issues on the table, so we invite, if that day comes up, we're willing to sit down and work it all out, and we wanna be at the table until we get this thing done. So we will check on our availability and Del Mar's availability here at the Economic Development Center for April 8th. If that's not possible, is April 10th a possibility?
April 10th is the day I'm supposed to be in Lubbock.
Oh, okay.
And the judge says I can't go. You know how judges are.
Yes, okay.
Did y'all hear the joke about the judge that died and went to heaven, and he saw God telling this angel to do that and that angel to do that, and he said, hey, who died and made him a judge? And I say that, judges, with all due respect.
That's
I love each and every one of them.
Let's get the sign-in sheet from last time. I need to sign in on your side, on the city side. I need to sign in.
Oh, you need to sign on
From
the
last time?
So sign in from last time?
Here you go. Anybody has it all.
I'll look and see if I have it.
Can we verify
Otherwise, it
it?
might be in our.
So Carlos Torres needs to sign from, that was 2/20?
2/20.
All right, the next thing on my list is that, I received an email from you. You sent it in the afternoon, but I unfortunately didn't see it till very late last night. I apologize for
That's
that.
fine, no problem.
But I just wanted,
Alternates?
our alternates, I think, have signed it.
I can't read
their writing.
Okay, that's the
Yeah, we're
bottom.
fine.
Okay.
Yeah, there. I'll look at this in a minute. But I did receive the email, and just to go over and make sure we have it, and we're working on getting that. We have 6 different requests. What is the city's contribution to firefighter employee only insurance? Number 2, what percentage does the city contribute to the firefighter pension fund for each firefighter? Number 3, what is the city's contribution to the police department employee only insurance? Number 4, what percentage does the city contribute to the police pension fund for each police officer? Number 5, what is the city's contribution to non-public safety employee only insurance? Number 6, what percentage does the city contribute to Social Security and Medicare for each non-public safety employee?
That one kind of caught me by surprise. Do y'all actually contribute to Social Security?
I can't tell you that off the top of my head.
Yeah, you do. So y'all aren't TMRS, or as opposed to, you do both?
Both.
Yes. Really? Yeah. Wow.
So, we are working on getting that information for you, and if there's any clarifications needed, once I get the request for clarification, I'll immediately email you.
Okay.
I don't know that will happen, but just in case, just letting you know, I'll do that. But I should have that, be able to have that information before, the session next week.
Okay, very good.
Okay? I just wanted to see if, I know that you had provided us with the wage data, and you said that you would be updating that, cause it was, I think it was incomplete at the time, and I just wanted to.
It is incomplete, but that document, I mean, I'm hearing from my guys that the document didn't go up on the website last week. Is that cause it's incomplete, or?
I don't know. In fact, I think we were having, just a delay in putting up documents. I don't even think our proposals are up there yet. I was working on that because I've submitted this as the whole document. So, all of that stuff, should be put on the website probably by the end of, this week. What's today, Thursday?
Okay.
I don't know, Friday or maybe Monday. We're kind of, I think, shorthanded on putting that, you know, the people who actually do that stuff. But I guess my understanding is that any documents that will be exchanged on the table, with respect to proposals or any information or documents provided will be posted on the internet so that there's a proper reference point on the video, and if someone's looking at the video, they can refer to the documents that we are talking about.
Right.
Okay? So no, that's not, we're working on that, that just still hasn't, been posted. So we'll just ask for you to update that whenever you get, that information. We have some proposals to, before I move on, let me look at this. Here we go, John. This to you guys. Each party should have the proper sign-in sheet. Here, we have added some initial proposals to our package of proposals.
Okay.
It's added to the document that we started to exchange last week. All of the new, there's 7 separate new proposals, and they will all be reflected in blue ink.
Okay.
So the black ink are the proposals that were, and what I need to do is I probably need to just date the proposals individually, but the blue ink is what we're going through today. And the first new proposal you'll find on page 7, and that is working hours. The second proposal is on the bottom of page 8, certification requirements. The next 2 proposals are on page 9. Number 3 is reimbursement of training and certification expenses. The 4th one today is departmental rules, standards of procedure, policies, orders, and regulations.
Okay.
The next new proposal shows up on page 14. It's grievance procedures.
Okay.
Let's see. The next proposal is on page 20, disciplinary appeals procedures.
Okay.
And the 7th proposal is the zipper clause on page 25.
Okay.
And those are the proposals that we have prepared to present today. We're still working on some others, but I don't anticipate that we'll work on trying to get them, but I don't anticipate that we'll be able to present them today.
We're going to talk about this at the caucus, but we hope to get some proposals to you today that are counters to the proposals you made last week.
Okay.
I have to express a little bit of frustration though, because, I mean, I can already see from this that a lot of what y'all have done is simply throw back at us the language of the current contract. And I had thought that we had agreed that we were gonna rewrite the contract from the ground up. And just to use your legal defense fund thing as an example, I rewrote that to, in its current form, it's incomprehensible. I mean, a firefighter would have to be a lawyer or need a lawyer to understand it, because it's just sentences that have been thrown together, it's an amalgam. Sometimes they're run-on sentences, sometimes they just flat don't make sense. And so I gave that to y'all as a proposal, and then you gave me back the language of the current contract, unchanged, word for word, the same incomprehensible.
That was on the legal defense?
Yeah,
Okay.
the same, and I mean, I can see it on some of these other proposals too, and the problem is this: if we're gonna rewrite the contract, let's rewrite the contract. Let's not just throw existing language back and forth at each other. I mean, your legal defense proposal, and this is just an example, is basically an acceptance of my proposal that I made to you, because I didn't propose to change the contract at all. But it's a rejection of the specific language, and the question is, why? What don't you like about that language?
Right.
And why, if you want to build the contract from the ground up, why are you guys just going back and throwing the old contract language at us?
Let me start with this. We are just putting down our initial proposals, which is basically establishing what I think the important part to establish right now is what the intent is.
What you want in the contract and what you don't.
Right, and I appreciate that you have worked on that language, and we will look at it, because if it says the same thing, I'll look at that again, okay? But what we're doing right now is we're putting our initial proposals first. Both parties have the opportunity to do that until March 5th, so we're not declining.
Yeah.
That's why it's not a counter proposal. It's not framed as a counter proposal, because at this time we hadn't declined or said no to your language. It's still up there, and I think that on issues like that, and we'll go back and we'll sit down and review those, and if it's something that we can agree to, then we, on the like for instance, the legal defense fund, we'll work on that. So I don't want you to think that we're just saying no right off the bat. We're just kind of trying to establish our initial proposal so we can.
What are the concepts that you want?
That's right. What are the concepts, and then that way we can work together. And because there are some more substantive proposals we've really been working on, trying to fix the language, and the legal defense, we just want to make sure that we captured all the elements that were there without leaving some out. So I'll look at that language and we'll work with that. We're not declining it. We're not, saying no to it at this point. So we're still gonna. I'll look at that. In fact, during our caucus.
Okay. So at this point, I guess. Well, before we caucus, why don't we just go through your new proposals real quick?
Sure.
And you said the first one was on page 7.
The first one is on page 7.
And you're going to send this to me electronically
Yes.
too, Rod?
I'm going to send it to you electronically once we go over. So if there's any corrections I need to do, I'll do them before I send you the electronic version. Then on page 7, basically.
Just as a reference point, this section 1, what part of the contract, current contract, does it reference?
That would be.
Who's got a current contract? John, can I see that for you?
Looks like it's, Article 4.
Comes out of Article 4?
Right. It's page 7, Article 4, Section 1, under working conditions, from the old contract.
Okay.
And
Do you need the current contract?
on the
Right.
basically on the work week and the duty hours for Section 1 and Section 2, we're calling
That's the current.
operational firefighters who basically assigned to respond to fire and emergency medical services.
The 24-hour shift people.
Right, the people who are on 24-hour shift and who are assigned to stations. Section 2 is the non-operational firefighters, or the firefighters who are basically assigned to 40-hour work weeks and don't respond to fire and emergency medical services. And so we're trying to
So, and like the current contract has like a section 1 and a section 2 that kind of do that too. They talk about
Right.
the work week for the operations people and then the 40-hour people.
Right, and we, you know, in that section 1 and section 2 of Article 4 of working conditions of the old contract, there's some stuff integrated in there about overtime or personal leave, et cetera. We left that out so that we could address it under those specific categories, such as overtime or personal leave.
Okay.
So we took that out as an effort, and what we'll also do is we will look at your proposal and integrate it and see what we agree on and what, you know, the things that we really need to work out.
Okay.
So as far as I can tell from my notes, I think everything is basically, you know, the work hours are the same. It just changed that distinction to operational and non-operational.
Okay. And I'm looking at the bottom of page 8, certification requirements.
Real quick, let me.
So this is, like, I think we had used the date October 1st, 2015, and you're using the date October 1st, 2014. And so you want the current class to be subject to the permanent certification requirement?
Yes.
And, I mean, have those people already been selected, or, I mean, who's gonna go into that class, or is the process that far along?
No, I
No,
don't.
we're still in the final phases of the interview process.
So I assume that everybody's being told that, hey, if you come in, there's a good chance there's gonna be a paramedic for life certification requirement?
No, we're telling them at this point, standard language, that they'll be required, what was reflected in the current contract. The 8-year certification.
The 8 year, okay. I mean, that's my concern, you know, like I said last week, it's not the date so much that bothers us, but if new people come in, excuse me, if new people come in, we need them to know what the rules of the game are gonna be, you know, so that, because if you bring them in with an 8-year understanding and then you tell them, no, it's life, we end up looking like bad guys, and we don't wanna do that, so.
So that was your reasoning for doing October 1st, 2015?
That was, yeah, and that was the only reason, was we didn't know what is being told this current crop of recruits. And if they come in with the understanding, you know, from the get-go that it's gonna be paramedic for life, then, you know, that's, you know, that's a whole different kettle of fish, so.
Okay. The next 2 paragraphs on that certification requirement, page 9, are meant to be grandfather clauses. The second one, and I think the October 1st, 2014 date here is reasonable. All firefighters hired before October 1st, 2014, and who still maintain their paramedic certification as of October 1st, 2014 must maintain their paramedic certification as a condition of employment. Failure to maintain said certification shall result in termination. The next one is also meant to be a type of grandfather clause, but once I read it, I'm going to talk a little bit about it because I learned some new information this morning that may affect this, and we're open to talk about it. The firefighters hired before October 1st, 2014 and who have dropped their paramedic certification as of October 1st, 2014 are not required to maintain paramedic certification as a condition of employment. Firefighters under this category must maintain their EMT certification as a condition of employment. Failure to maintain said certification shall result in termination. When this was written, I was under the understanding that all firefighters were required to maintain their EMT certification. I learned that then I found the provision. I think the tier is people who were hired after a certain date in 2006 are required to maintain that. So there's a tier of people who may not have. I think it was about 25 or something like that. There's a certain tier of people that do not have their EMT certification at this point, and the intention is not to force them to get it. It's to the grandfather, and I just didn't have that information at the time. So we'll be willing to talk about that.
Well, talk to me about the people that, let's say, have paramedic certification now, but were told that after 8 years, they don't have to keep it. So this would be definitely a change as to those people. And, I mean, I can tell you that that's a problem for them because, you know, again, it's changing the rules of the game after they've started. It's like telling you that, well, you have to get labor law certification or you're gonna lose your job. Well, you didn't tell me that when I hired on and I left another job to take this job. Well, no, but we need you to be labor law certified because, you know, we're having a lot of labor law problems. And then, I mean, you would feel that, well, that's not, you know, that's not fair. I mean, if you told me that before I came in, then I would have had the choice to do it or not to do it. And so I'm just asking y'all to think about that because you're talking about changing the rules of the game as to people. And I think that you're gonna have some quantitative easing here with your paramedic problem when you get the new people in, all of whom are gonna be paramedic certified or certifiable, you know, within 18 months. And a bunch of them may already be certified, I don't know. But, I mean, that's, you know, because at the end of the day, I have to have a contract that I can get my members to vote to accept. And if you know, I can foresee a situation in which, you know, if you, I mean, I don't want there to be any surprises. You say, okay, after this contract becomes effective, you have to keep paramedic as a, oh, well, man, I'm gonna drop it before this becomes effective. And so you might have unintended consequences.
Well, and we don't want unintended consequences to happen like that. That's why we're saying if you were already certified on a date certain in 2014.
Well, it just talks about people that are hired.
On the grandfather clause, it says, the last two, it says firefighters hired before October 1st, 2014 and who still maintain their paramedic as of that date.
Okay. Okay. I mean, it's a problem.
And
it's a real problem because, you know, again, you're changing the rules of the game on them. And this, you know.
Well, and just like in any other job, you know, I can come in being hired as an attorney to handle litigation. And all of a sudden, we lose all general litigation, and the majority is all labor and employment law litigation. And my boss says you need to, the dynamic of what we deal with here in our operations has changed, and we need to address that. And if, you know,
but it hasn't changed.
Job,
yeah, it hadn't changed in the last 3 years. What's
but
changed in the last 3 years is that you stopped hiring new people. I mean, that's the only thing that changed. And the call volume increases year to year, but you're not going to see a sudden spike in EMS call volume in the last 3 years. You're just not. What you're going to see is a sudden drop in hiring in the fire department in the last 3 years, and you don't have enough bodies to cover everything you need to cover. And so to deal with that problem, instead of hiring, you're talking about, well, we just need to make everybody be certified now.
right. Well, and I don't have the data to tell you whether that's right or wrong, and I'll look at that. But I will say that I do know that 80% of the calls that are made by the fire department are emergency medical response calls that require an ambulance. Usually there's a firefighter truck and an ambulance, and we want, you know, we offer a top tier service. We offer advanced life support services. We have a very, very good quality service that we provide here in Corpus Christi, and we've been able to do that because of paramedic certifications that we have.
And Roxy, I'm going to tell you.
And that's what we're doing.
Yeah.
And, you know, 2% of our calls are fire-related calls. The other 18% are miscellaneous, you know, false alarms, you know, all sorts of other things that people call the fire department and they get called for. So what we're looking at is to address the community needs, the operational needs of the department, and we want to maintain that quality of service and even make it better.
See, but you're building your whole argument on a false premise. And the false premise is this. in 2014 and 2015, 80% of our calls are medical calls. But in 2005, that wasn't the case. I'll guarantee you that if you go back to 2005, and that's 10 years ago, your call volume in terms of medical versus fire won't have changed 5% more or less, up or down. This is not a problem of the changing dynamics of the fire department. This is a problem of not hiring in the fire department. We've said that we're not going to make a hiring proposal, we're not going to make a staffing proposal, and with one small exception, we've kept that promise. But that doesn't mean that we can ignore the cause of the problem. The cause of the problem is not that you have fewer people that are paramedic certified. That's not the cause of the problem. The cause of the problem is that your city has grown, your call volume has grown because your population has increased, and the fire department hasn't grown. You put more ambulances in service, but the fire department has shrunk. I don't know what the statistics are, but you have people that retire every year, and when you don't hire to replace them, these problems develop, and that's what's going on. And you're addressing the problem right now by hiring a new class, but it's not fair, and fairness is an issue for us. It's not fair to solve a problem on the back of the firefighters that they didn't create, and by essentially backing out of promises that you made to them and that they have relied upon, now possibly to their detriment. And so I'm just saying, you know, I mean, I've said all along, and I say it again, the solution to this problem is not us trading proposals back and forth, you know, like this. This isn't very productive. What would be productive would be to get a subcommittee of city people and union people, and let's sit down and try and work out a solution to this problem that works for everybody. That solution is out there. I can't articulate it for you right now, but I'm confident that our two teams working together can come up with that solution. And I'm asking you again to do that. And the subcommittee is no threat to the city because the subcommittee cannot cut any deals away from the table. The deal still has to be made here at the table. All they can do is bring a recommendation back. But, you know, we could be focusing on getting the whole rest of the contract worked out here while that subcommittee does the down and dirty work that we need to address this problem. And so that's why I'm asking you to do that. And, you know, I mean, this is our 5th session, and the city still hasn't responded to that request for a subcommittee. But what we are doing now is throwing back and forth proposals that were made last year that kind of led us to the impasse that we got to. And that's what I don't want to see happen here.
So are the firefighters now who have their paramedics, who maintain their paramedic certification, are they just unwilling to continue to maintain the certification? I don't, you know?
No, I honestly think that what they told you, I know in the last session, and would repeat for you again today, I'm sure, they will say that 95% of us have our paramedic and we're willing to keep it, but you're burning us up on the box. And, you know, we need to know that there's some relief from serving on the ambulance available at some point in our careers. And, you know, the paramedic certification is, if it was only keep your paramedic certification, but the 8 years riding on the ambulance, we won't change that rule. But I know, you know, what's coming next. It's going to be keep your paramedic certification and you have to ride the ambulance for as long as we want you to. I mean, that's what's going to come, right? And that's a solution that is a lose-lose solution. The firefighters lose because they're getting burned out. The city loses because they're forcing firefighters into premature retirements. And I mean, that's what happens in the fire service. And when you have a situation where people can't get off the ambulance, and I mean, I would go so far as to encourage members of your team to do ride-outs on the, just spend 24-hour shift and do a ride-out on the ambulance where you don't get to sleep for 24 hours. You're constantly on call. And just figure out if, you know, putting people into that assignment permanently makes sense. I mean, Austin Austin EMS, you know, they have a situation where they have, you know, all they can do is ride the ambulance because they're an ambulance service. The way they've done that is that they only work 2 shifts a week instead of 1 on, 2 off, you know, where you're averaging 56 hours a week. They average 48 hours a week. They cut their hours and they have to bring more people in to do that. And even so, they still burn people out and don't retire. So what we're asking you to do, instead of us keep, beating our heads together like this, is let's get a group of people working together to work out the solution. And it doesn't have to be members of your team here. It can be the fire chief. It can be, anybody that you want. But it should be somebody from your side that has experience in the fire service and knows, what the problems are and what the realities are for the people on the ground. And if we do that, I think that the solution to our problem is out there that will result in something that the city can live with and will be a good thing for the city and the citizens, and something that will be good for the firefighters too. And it may, and you know what, it may be different. The firefighters may cede ground in terms of how long they maintain certification or whatever. I'm not saying they will or won't. I'm saying anything's possible. But when you're working cooperatively to try and find a solution, it's a lot easier than simply passing demands back and forth across the bargaining table. So, again, my request is that we form that subcommittee. Let's give this issue to them and see what they can come up with.
You mentioned that firefighters are being forced into early retirement. Do you have any data that that's the case here in Corpus Christi?
No, I don't. And the reason that I don't is because right now firefighters can get off the ambulance after 8 years. I mean, and they know that, and so they don't retire early. But I'm saying if you change the rules of that game, I think that's going to happen?
That's at the discretion of the chief as well, due to the operational needs of the department.
Mm-hmm. Well, there's an arbitration decision that says that, but that's never happened. And I mean, again, I don't want to. I'll stop beating the horse if you'll agree it's dead. But this is only a problem in the last 3 years, and it is, and the reason is really very simple. You haven't hired in the last 3 years, and your fire department has shrunk at the same time that you put 2 additional ambulances into service. And so you need fewer people to do more medical work. I mean, and that's the problem, pure and simple.
Now, if
and we're not putting a hiring proposal on the table. I
well,
promise
you did put a staffing proposal on there on ambulance stations. So
only with regards to making sure that the personnel are there that you need to do the job. I mean, I'm telling you, and I haven't made a secret of it, the solution that you currently have implemented, in my opinion, and just so you know, I've shared this with my bargaining team, is illegal. Okay? It violates the Civil Service Act, and I litigated a case like this in Fort Worth, and in which the firefighter position prevailed. It just didn't get back past the district court.
which specific issue is
It's the
that
issue
the alternative
of
hiring?
No, yeah, it's using firefighter ones. I mean, in other words, it's using firefighter ones to do firefighter 2 duties without creating sufficient firefighter 2 positions. I've litigated that issue twice, once in San Antonio, once in Fort Worth. And what y'all have done in effect is you've created additional firefighter 2, de facto created them without your council creating additional firefighter 2 positions. And so, and what you're doing is you're assigning firefighter 1s permanently to firefighter 2 work essentially and giving them move-up pay. And so, you really have, 5 firefighter 2 positions and 5 firefighter 1 positions, but you're staffing 7. In each shift, you're staffing 7 firefighter 2 positions and 3 firefighter 1 positions. And so, that's, you de facto created additional positions. And I had the same situation in Fort Worth, where they put another fire truck in service out at one of the airports, and they didn't create a driver position for it. And they just kept, temporarily promoting firefighters to drive every shift. And the court said you can't do that. That violates the Civil Service Act. So, I'm trying real hard, to avoid, this whole hiring issue and staffing issue, because I don't think that's productive for us. But I can't ignore the reality. And the reality is because you haven't hired a class in the last 3 years, and you have fewer people, and because the medical work is 80% of your call volume, run, you know, you're doing the same amount and probably an increasing amount of medical costs because your population's growing, with fewer people. I mean, that's not rocket science. I mean, and so
Have
it puts
we-
more pressure on people.
Have we lowered the number of firefighters in the last several years?
Yeah, of course. You haven't lowered the number of positions that you have created, but you have firefighters who are retiring, resigning, quitting, whatever, and they're not being replaced. And so the number of your authorized complement, you're like 40, I believe you're 40 positions down right now from your authorized complement. That you have 40 fewer firefighters. Guys, am I wrong about this?
You're close.
You're close.
You're close to 40, you're close.
You've got 40 more positions authorized in the fire department than you have bodies right now.
And we've implemented a
And all
hiring
40,
process to do
yeah,
that.
and all 40 of them, by the way, are in the firefighter 1 rank. Because under the state law, you have to fill promotional vacancies as they occur. So, you know, all 40 of your vacancies, and I may be off 2 or 3, but all of your vacancies are in your lowest rank. And so those are your tailboard folks. Those are your people that ride, you know, on the, primarily are supposed to ride on the fire trucks. So, you know, you're running short.
So we're implementing our hiring and academies in order to, you know, and I don't have the numbers or the statistics in front of me with regard to the hiring, but, you know, we haven't hired in the last several years.
And you may have had incredibly good reasons for doing that, but do you know how many of y'all are gonna hire in this class? Has that been decided?
We still have not got that number.
But,
Where does that number come
but
from?
what,
Who gives that number?
I would assume the city manager or the staff.
what are you
finance.
asking?
We're just asking how many you're gonna hire in this class.
He was saying he hadn't got that number yet. I was saying, where that number?
Well, the
Who
fire
decides
chief
the
Well, I
number?
mean, they have to figure out who's gonna be, eligible to get into the academy, right? Are you still doing recruits and
We're
interviews?
currently establishing a eligibility roster, that's been in process, but I think the final number, how many we're actually gonna put on is a combination of things that.
How many you're gonna bring into the
Actually,
class.
right.
Yeah.
So-
I think I know.
Which is?
The city has authorized 17, possibly to 25. The chief wants to hire 40.
Our goal is to
Where
hire
was
as many
that
as
city's
possible.
authorization done through?
That I don't know, but
So
that's
where are
from
you
Chief,
getting-
Chief Rocha.
Right, and that's why I'm asking, where are you getting that information from, just so I can
Chief
verify
Rocha.
it?
I mean, I'm sure it's a
so-
budget issue.
Well, let me finish on my thought here. Okay, we're employing our hiring procedures, we're addressing that issue. So how does the certification affect the hiring issue? The certificate, I mean, we're asking that everybody in the department who currently maintains their paramedic certification, maintain it as a condition of employment. It's 80% of what the fire department does. Emergency medical responses that require paramedics, and we have the ROSI, really high ROSI score. As I said, we have advanced life support, et.cetera. So I think certification and hiring are two separate issues. I understand that you believe that it's a factor in hiring's obviously a factor in staffing. If you don't hire, then you don't replace the people who are retiring. I need to look at the rate of retirements, the rate of people leaving, etc. I don't have that in front of me, so I need to look at that in order to verify what you're saying and be able to evaluate that. But we're talking about certification requirements here. Certification requirements ensure that we have the people in the department to provide the service that we promise to the taxpayers and to the community. And I think that's our goal. We've seen what, even though you're saying that the dynamic of the operations hasn't changed, that it's been 80% the last several years, it has changed from the beginning that it became a fire department. When this fire department was first established, through I've gone back through the collective bargaining agreements. It's like the mid-70s, sometime about 75 or 76. I can't remember the exact date. But that's when we started doing these collective bargaining agreements with the fire union with regard to working conditions, hours, compensation, etc. At that time, it was a true fire department where all they did was respond to fires. And that's the way it was established. Of course, as the community grew, population grew, the needs grew, etc., the dynamic of what the operations have to address has changed. And that has become 80% emergency medical calls, 2% fire, and 18 other miscellaneous. So that's where we're trying to address, because as you know, when we're coming up to these collective bargaining agreements, we recognize that we would better our department, better the service that we provide to the community, to require people to have paramedic certifications. And ultimately, it's a step in order to come to a department that maintains, that has all paramedics. And when firefighters sign up for this job and they go through the academy, they understand what the statistics are with regard to the type of calls, etc. So what we're looking for is to, let's maintain and improve what we have. If, you know, the firefighters right now, 95% of them maintain their paramedic certification, and they've gone past their 8 years, then, you know, why would they want to lose that and not be a paramedic when they offer top quality service as a paramedic, and they have for so long?
The reason they would want to do that is because that's the only way to get off the ambulance. If what you're proposing as a city is simply that they have to maintain paramedic certification, but we'll leave the 8-year and the 5-year ambulance requirements untouched, then I stand corrected, and I'm wrong, and I'm not guessing correctly where you're going.
Well,
but I know that once we agree to certification, the next proposal you're going to make is going to be this. Oh, in the 8-year and the 5-year requirement, we need to modify those. Because you said something that's very important, and I want to say it back to you. You said we've got to keep providing the level of service that we have promised to the citizens. And you're proposing to do that right now with what I call a Band-Aid proposal. A Band-Aid is, as our staffing numbers decrease, the Band-Aid we're going to put over this wound that we're creating is we'll make our people be paramedics, and we'll make them serve on the ambulance longer than we make them do that now. And that'll work for a while. But if you go another 3 years and you don't hire a class, and now you're 80 down instead of 40, you still won't have the bodies you need to provide the service to the citizens that you have promised and that they have come to expect and that they deserve. So a Band-Aid solution won't work. You can't indefinitely continue to do more with less, and that's what you've been doing. And you know, even now, I think what we're going to find is you're 40 positions down below the strength that your city council has said we're going to have. We authorize you to have X number of positions. You're 40 down from that, and even after this hiring class, you're going to probably be more than 20 down from that. And it may be that that makes sense because of the economics, etc. I can't argue that with you. But what I can argue is this, is that, you know, you're overutilizing a valuable resource, and when you overutilize something, when you go to the well too often, you burn it up. And I'm not basing this just on Corpus Christi. You want to ask me, well, give me some facts and figures in Corpus Christi. I can't do that. But I do have experience around the state. And I'm telling you that you can burn up a resource by overutilizing it. You know, if you use a fire hose too often and you don't replace it, pretty soon it doesn't adequately do the job it was built to do. And it's the same with the firefighter. You know, if you stick them on the ambulance and leave them there 10, 12 years without a respite, they're going to burn up. And, you know, that's not what I want. I don't think it's what you want, you know, and the economics may be that, you know, at some point you've got to do that sort of thing. But you got to look long range, because that's what we're really trying to do here, right? I mean, I'm trying to protect the working conditions of the firefighters, admittedly, but we're citizens too. We want a top flight ambulance service for the citizens. And, you know, you say, well, true fire department, not true fire department. You know, the whole trend nationwide is that emergency medical service is becoming part of the fire service. In fact, the Fair Labor Standards Act was amended so that you can use the 53-hour work week without paying overtime that firefighters enjoy for your ambulance service. So you benefit. I mean, the city and the citizens benefit from fewer overtime hours by putting ambulance service in the fire department. And my hat's off to you in Corpus, because you've got one of the best ambulance services in the state, maybe in the nation. And, you know, we're honestly on our side of the table trying to find a way to help you maintain that. And we've already offered, if you'll grandfather people, to change the rules of the game for everybody coming in, you know, and over time that will, I think, help you. But it won't solve the immediate problem. Hiring would solve that, but we're not gonna try and dictate that to you.
Right, and
We're just trying to protect our guys.
We're working on hiring, and let's talk about ambulance duties, since you brought that up right now. In the fire, you know, if the calls have been 80% medical emergency response, and those mostly require an ambulance, that's known to people when they're coming in, you know, candidates, cadets, firefighters when they're coming in, especially if, as you've stated, it hasn't changed. But what we're having here with the, you know, when you're saying you require the certification, but you're gonna wanna be able to opt out of the ambulance, is the ambulance is required on the majority, 80% of these calls. So what you're doing is, in essence, even if we were hiring, you know, every 6 hour, however, the quickest we could hire pursuant to whatever were the limitations in the law, you still have a pool of people that come in knowing that the ambulance duty is going to be used in 80% of these calls, yet after a certain amount of time, the pool on the people who ride those ambulance gets smaller and smaller, because you have these people, you know, the 8-year currently, it's at the discretion of the chief pursuant to the arbitration award, but before that it was, you know, they were just demoting or getting off the ambulance after 8 years. So then when you're talking about burnout, you essentially have a large pool of people who are paramedic certified, but then when they opt out of riding the ambulance, you have the majority of these calls being covered by a smaller pool of people. So, you know, essentially, that's a factor that you also have to consider.
I agree with you, but if you're down 40 positions, you already have that smaller pool of people problem.
And then
you've
it
got
gets
people
smaller,
like Johnny here
and
who
then
are
it gets-
captains,
and then it gets smaller when they opt out of the ambulance. So then we have a very small amount of, we potentially have a very small amount of people riding the ambulance even more because of that.
It's exacerbated by you not hiring. That's what's making the problem so pronounced.
See, a couple of things. Number one is, it's a misconception that it's the ambulance that responds to medical calls. On 70% of your medical calls, a fire truck arrives first. Okay?
First, but an ambulance usually
An
arrives
ambulance
right
follows,
after.
right, but so you don't get out of doing paramedic duties simply by riding on the fire truck. So that's a misnomer. You get to do other things besides just respond to medical calls when you ride on a fire truck. So, you know, even though 80% of the medical calls, I don't want the citizens to think that, you know, fire trucks aren't doing that much, because they're responding to a heck of a lot of medical calls.
I agree. They're responding to medical calls, but they're usually followed by an ambulance. So in most cases, as I understand, I think the fire truck's usually the first one to get there. Yeah. And the reason that we benefit from that is because we have paramedics on there. And we would like that to continue. We would like to guarantee that if a firefighter, a fire truck, as the trend has been, is usually the first one to get down an emergency medical response, that we have a paramedic to address that. Because there may be times if we allow people to drop their certification, not ride the ambulance, etc. We have a fire truck that shows up, and for some reason we don't have paramedics to be on that truck. They show up. They may have an EMT basic, depending on what tier they are, because there's a small number of people who aren't even required to maintain their EMT certification. What if that happens to to be people who can't address that emergency medical situation right away, like we would like to address.
Well, see, number one, we've already told you that despite the fact that people can drop their certification, almost nobody does drop their certification. The only reason people have started to consider dropping their certifications is because that's the only way they can get off the ambulance and they're burned out.
And
I'll add something, if I may. And I've explained this to you before. I've been here for almost 27 years. I still ride an ambulance. That's by choice. The fact that I've been able to do it for that length of time is because the workload hasn't been so difficult for me. I ride a 50% on, 50% off a rotation. It has changed in the last 3 years, 2 years specifically, to where I'm not riding 5 shifts a month. I have 10 shifts a month. I'm not riding 5 shifts a month. I'm riding 8, 9, and 10 shifts a month because the lack of people that have been hired has forced those of us on the ambulance to ride the ambulance more and the fire truck less. So when you talk about burnout, it does play into it. I mean, and we can get you numbers on how many of our guys have committed suicide. We can get you those numbers. We can get you numbers on how many of our personnel have gotten DWIs. We can get you numbers on how many guys have gotten divorced in that rate. It's not good nationwide, and there's all kinds of documentation for that. But I'll tell you at this table, Brendan, how many years have you been on the ambulance?
9.
Randy, how many years have you been on the ambulance?
15.
I've been on 26, almost 27. Scott rode the ambulance for 12 years before he promoted to captain. It hasn't been a problem of people opting off, as you call it. There's always been an avenue to promote and a rotation out of it. You've always had ambulances well staffed. But in the last 3 or 4 years, the demand has gotten so rough because of our short staffing, it's putting a pretty good load on us, to the point where even I am getting tired of it.
now, if,
Roxy, can I say something? I've been using the number 40. I'm told it's 32 right now, but the 3 people are retiring at the end of March, so it'll be 35 at the end of March.
I'd like to respond to what Steve was saying. He said that in the last 3 years, he's been riding the ambulance more. In the last 3 years, we've also had a number of firefighters opt out or try to opt out of ambulance duty. If those firefighters who had opted out of ambulance duty were still in that rotation, wouldn't that ease you having to ride so much?
You've also added 2 more ambulances without increasing the staffing.
But I'm asking
That in
you-
itself put a big
I'm asking
damper
you,
on it.
wouldn't that help
Of course it would,
ease
Roxy.
it?
Of course it would. But,
we know.
but it wouldn't go back down to 5.
No.
Instead of being 9 or 10 a month, it might go down 1 to 8 a month. But it wouldn't help. It wouldn't help in any kind of dramatic fashion. It wouldn't get it back to where we were. You know, up until 2 years ago.
And
people
that's,
only
like you
roll the
said, it's a
ambulance half the time.
hiring issue, and right now we're employing hiring process, and we know it's something that is an issue, and we're addressing it, and you know, of course, we have to follow limitations and the processes by which we're bound to by law and the statute, so you know, that's something that's being done. But you know, when we're talking about certification and hiring and staffing are 2 different issues, and I understand where you're saying that it's a factor in what y'all are talking about, but that is not the only factor if it affects it. So we need to have more discussion about that.
Right, I
And,
agree. I don't know how productive it is
Right.
across the table. I mean, I really think we need a working group on this, and I'm not saying that. I'm not saying that to evade the problem. I'm saying that because I want a solution to the problem that works for the city as well as for the firefighters. I mean, I believe that solution's out there, but I think we need a group working on it in between our sessions here, you know, to really focus on. And by the way, the guys just gave me a little news story And it reads paramedics under pressure, alarming suicide rates, rock ambulance service. And I don't know what ambulance service that's looking
Now,
at.
is this a
but-
nationwide deal?
Yeah,
Is
it's
this
not-
a
it's
Texas
not-
deal? Is it a
No,
Corpus
yeah,
Christi deal?
absolutely. It is
Okay.
not, we're not relating that, to Corpus Christi specifically.
But it is a nationwide thing.
Craig, if I may,
Okay.
thank you. And we need to remember that the way we built our system, we have a top-tier system, everybody agrees on that. The way we built that is through the processes, the procedures that we have in place. And it has allowed for an adequate rotation and replenishment. And this is anecdotal evidence. I mean, that's the way we got here. And now we're going to change it. I think we also need to realize that the city has started hiring somewhere in the normal range. That's good, that's fine, and we would expect that you would try to make up the deficits that were there. However, you know, there's gonna be this transitional phase where it's gonna take us some time to get there. Let's not throw the baby out with the bathwater. There are things that need to be fixed, but do you really wanna redo this entire system and leave what got us here? You know, one of my rules for life is, if it isn't broken, don't fix it. Now, we do have some things that need to be fixed here, but they're not to the degree where you wanna throw. What allows the firefighters to maintain this high level of performance is the fact that they know that they're gonna give these 5 to 8 years all-out effort. They're gonna work their butts off. They're not gonna sleep at night. Those are the working conditions for that period of time, and they're willing to do it. And they're not gonna quit, because see, that's the other thing, they do have an out, no matter what we do here, and that's, bye-bye city, I'm done with this. And that is something that a lot of paramedics come up against. It keeps them from taking all that training, all that money that the city has invested in them, and just going to something else. Is the fact that they know that there's a line that if they get across, they won't have to do that anymore. And so our task really is to preserve the good things about our system and perhaps tweak those that need tweaking in order to get through this transitional phase while the city rebuilds manpower to the levels where they should be. And we really gotta get around that. I mean, we're not entrenched in any particular thing. We know that there's issues that need to be done, and we're willing to work with the city. But at the same time, you gotta realize that we have legitimate concerns. And it's for the betterment, it's for maintaining our excellent system, because we really don't wanna go backwards.
You know, Roxy, Frank raises a really interesting point, and that is the current problem you have, is it a permanent problem, or is it just a temporary problem? I mean, as your economic situation eases and you hire more firefighters, is this problem gonna recede? And we think the answer is yes. And y'all obviously think the answer is no. But you don't wanna come up with a permanent draconian solution to a problem that's gonna go away, you know, when you're able to hire adequately. And so that's the kind of thing we're looking at. But, you know, I don't want you to think that we want to preserve the status quo just so everybody can give up their paramedic certification. Almost everybody in the fire department is certified at some level, most of them at the paramedic level. And I don't see that not continuing unless you try and change the rules of the game such that there's no way they're just going to become permanent ambulance people. Then, and you know, you said, well, everybody who comes in the fire department knows we got an 80% call volume. That's, you know, the general public, and that's firefighter recruits. When they think of joining the fire department, they think about fighting fires. They don't know that 80% of their time is going to be spent making medical calls. I didn't know that before I started representing firefighters. But, you know, I know it now, but it's because of my connection to the fire service. So they don't necessarily know that, and they do need to be equating with that right at the get-go. They need to be told what, you know, hey, you understand you're joining the fire department, that 80% of its calls are medical, and here are going to be the rules for you with regards to making medical calls. Now, do you want to come on the fire department? But then when you've made a promise to them, keep the promise.
Okay, I think this discussion is good. It's bringing the issues out, and it shows where we lie. I think in order to have a more fruitful discussion here at the table and to consider whether this is something that needs to go out to interest-based bargaining, which we refer to as IBD, I need to look gather some of this information that we've been talking about to verify what you're talking about. I think if we have the information at our hands, we can have a more fruitful, comprehensive discussion. And so I anticipate we're gonna be really getting down to, discussing details, et cetera.
And you know, your assistant chief is not here today, and
Right, the deputy chief, excuse me.
Deputy chief, excuse me. But I think that if he were, he could verify a lot of what we're saying to you the first time you go into caucus, and I think your chief can too. I mean, these are not things that are unknown to your. I mean, these are not things that we know that your side does.
Right, I just don't have them on the top of my head or at my fingertips at this point, so.
But why don't we turn from this topic and talk about other topics, because, I think that it looks like you have not added to the compensation piece yet.
No, we have not, and that doesn't mean that we're not going to.
Oh, I know.
But we've added to working conditions, the grievance procedure. The major thing here was trying to, on the grievance procedure, a grievance was not defined. It was kind of open, and so what we're doing here is trying to establish what the purpose and the scope of the grievance procedure, what a grievance is. One of the things that we've done here is that a grievance would be filed by the union on behalf of an individual firefighter, a group of firefighters, or the union itself. So it would be the union forwarding the grievance because of the union grievance committee. One of the other things that I would like to address, and I left it open here, was that the union grievance committee basically serves as a gatekeeper in this procedure. Unfortunately, the city, relying upon the union grievance committee in terms of the past procedures and this current proposal and the proposal that you have put on the table, which we need to see what parts we agree on and what parts we need to work on, and I'll look at your language. I'll be looking through that. We need information, and we would like to maybe define the purpose and the scope of the union grievance committee, just so we have information, and if we're relying upon it in this procedure, that it's defined on what it really does within this process.
I'm not quite sure I'm understanding you. I mean, that essentially is what the union does now. I mean, it acts as a gatekeeper, although individual employees file employee grievances. If the union doesn't forward it at step 2, it just dies there without the city ever having to become involved.
Right,
so in essence, they are already union grievances by the time they get to y'all.
Right, and we just want to establish somehow, some way that the union grievance committee is essentially the gatekeeper. It's just not identified anywhere in the process. It just says it, we want to, it may be the gatekeeper, but is it, and I'm not saying this happens, but, are the doors wide open all the time, or, we just need to establish that it is a gatekeeper and that it's part of the process, and because it's part of the process, the union and the city both understand what that committee is and what it does.
What do you mean by the door wide open?
What she means, what I think she means is simply that if the employee wants to file a grievance, we don't do much of screening.
And I'm not saying that happens, but, if it's part of the process, I think it just needs to be identified here so that we're both on the same page about what that union grievance committee is, what it means. And that's the only thing on that.
And I look at this, I mean, off the top of my head, it doesn't look like your grievance article is that much different from mine.
It does incorporate a kind of a little bit of a discovery process.
Discovery?
Well,
where is that?
let's see, on page 17, it kind of adds some procedures for the process. What's happened in some grievance procedures is that the city was under the assumption that all the information, et cetera, and this stuff related to the grievance was part of the actual grievance original form, the notification. And then we get to arbitration, and they're waving around like, some memorandum of understanding we just didn't know existed that relates to, that they're basing their grievance on. So it basically allows, upon request of a party, you know, to ask for certain things if you're relying on them. It asks for the parties to exchange documents a certain time before the arbitration. It asks for, identification of witnesses on both sides, et cetera, things like that.
Okay. Can I ask, just because I'm curious, how many grievances here have actually gone to arbitration in the last 3 years under the current contract?
I have to look at that, but I'm trying to remember. I know we just had one, and we have, 2 that were currently set, but were, rescheduled or on hold. I have to look at that, but there are several that have actually gone to, arbitration. I know there was a sick leave policy one, and I'm working on getting that information from
I mean,
as well.
yeah, I'd appreciate that information from you. I mean, you know, last week you said that there have been like 30 maintenance of standards grievances.
Well,
And I asked my guys to get me the totals on that, and since this contract went into effect in 2011, so that's 4 years ago, there have only been 5 grievances that have been decided only to maintenance of standards. In some other grievances, they cited maintenance of standards along with another specific
Right.
provision of the contract. But of the 5 that involve maintenance of standards, only 2 got as far as arbitration. The other 3 were settled pre-arbitration, so I'm not.
And there's some others on it, and I'll get you that information, I'll look at it, and I was going off the top of my head, but I recall, I was here in 2011, and then I, had to leave, and then I came back, and when I looked at the chart of what had been pending since approximately 2011, I recall approximately 30 of them, the majority of them in some way cited, prevailing rights. So
If our information is
from what
right,
I
only
recall.
14 have cited maintenance of standards at all.
Okay, so
But-
14, so.
But of those 14, 9 of them primarily relied on another specific provision of the contract.
Along
only-
with maintenance of standards.
Well,
right?
they cite maintenance of
Or
standards,
prevailing rights.
but only 5 are true maintenance of standards grievances. And the reason I say that is because, you know, I'm looking ahead to a solution. I mean, if you want some discovery in the arbitration process, that's fine. I mean, the AAA rules allow for subpoenas and discovery right now anyway. So I would think you could already do that. But if you want to put it in the contract itself, you know, my off-the-cuff reaction is I'm not particularly averse to that, so.
Okay, and it's just, you know, it deals with issues that we have faced recently, on just making sure that all the parties have what, you know, we don't wanna show up and waive a document and you've never seen it either, you know, we're not interested in trial by ambush, that's not what the goal of going through this procedure is. Because
I know.
if something comes up and you say, oh my gosh, we didn't know that this memorandum of understanding is very relevant to this, instead of waiting all the way to arbitration, if it's something we can consider during some part of the process, then
You know,
it
yeah.
becomes very relevant.
That's like almost shocking to me because I can't imagine getting to arbitration. You've gone through all the lower steps of the grievance procedure, talked to the fire chief, talked to the city manager, and nobody's mentioned that there's an MOU out there, a written MOU that actually addresses the issue.
There was some issue about that,
I mean, quite frankly, that's a failure on the union's part because under the language of your current contract, you're supposed to cite the specific provisions.
right, and and there were, in one, and I don't remember the subject matter, it put it in on a voluntary demotion deal, something like that. And there were several grievances with regard to voluntary demotion, so I don't remember exactly which one it was. But I do remember that a memorandum of understanding came out way later, right before the arbitration, that hadn't been cited in the actual grievance, the notification of the grievance. So, those are things, and, yeah, and those are just the things, like, if they are relying on something that's outside the collective bargaining agreement, that is relevant to that, we just wanna make sure that we have the opportunity to appreciate it
Okay.
and to consider it,
Okay.
et cetera, and.
Let me look at it.
Because without it, we may say, no, you know, that's not something we can resolve, and then, but if we had that information, say, oh, you know what, maybe this is something we need to resolve, kind of deal. It's just to kind of make this the process more meaningful and be able to have all the information so that we can make a
Yeah.
informed decision.
I mean, my sense here in Corpus, and I could be wrong, and correct me if I am, but the process, I mean, grievance arbitration is supposed to be expeditious. It's supposed to happen pretty quickly.
Right.
You know, because we don't want these problems festering. And it sounds like it's not expeditious here in Corpus, that things take a long time to happen. And so that's like a concern that I have. But, you know, more open sharing in the grievance process would go a long way toward, maybe resolving some of these things. Because don't y'all have a loser pays
Yes.
system already?
Mhm.
I mean, that's how you know we're gonna be honest gatekeepers.
Right.
We don't wanna pay for frivolous grievances, believe me. You know, we don't say, oh, you only got a 5% chance of winning for that, but hey, we'll pay for it. We wanna save our
And
money
as
for our
we-
attorneys,
yeah.
right? In
That's
theory.
right.
In theory, yeah, in theory, yeah.
And
So,
as we both know, those grievances cost you know, just an arbitrator's costs and expenses are, you know, the neighborhood of $5,000 and sometimes
It's-
more, depending on how long the arbitration hearing lasts.
you know, and I have
And that's
seen
just
that
the
over
event.
the course of my career, and it's unfortunate, is that we have really legalized the process of grievance arbitration. And, you know, when I started back in the Stone Age, you know, the typical grievance arbitration hearing lasted one day. Now it's not uncommon to have them last 3 or 4 days.
That's right.
And that's.
Even a one-day arbitrations are expensive.
Can
on
be,
top of
but
that.
boy, you get an arbitrator back 3 or 4 times with all their travel expenses, and, you know, now it's not quick, it's too expensive, and somebody's gonna end up, you know, paying the freight for that. So, I share your concerns, and let me just look at it.
On the grievance. Roxy, on the grievance procedure, last week you had asked us about our vetting procedure for that committee. And I didn't think of it at the time, but it's not just like we have a bunch of yahoos on the committee. There's guys that have been on that committee for, I can name 2 of them been on that committee for over 20 years. You know, so there's a lot of experience. You have new guys that come in, that's true. And we talked about the gatekeeper function. And that committee, although you've seen 30, to use your number, 30 grievances.
And that's just, you know,
I
a general idea.
understand.
And
And I think that number's more like 27, but there's also been 27 you haven't seen because the gatekeeper did its function. But on that team is a lot of experience on that team. New guys come into the team and they are taught by, on the job training, stay with the process, and before you know it, it's like me and Frank. We've only been on that committee for 10 years, Frank. But there's other members of that committee that have been there a long time.
Right.
And there's guys that have been there shorter than us, and that's the vetting process on
Okay,
that.
and I don't wanna give you the impression that we don't think that we just don't know anything about.
Yeah.
And we were just wanting to be
It's
educated
understandable.
about what it is and who's on it.
And I think it's important to know that how many of that committee stops. I've stopped 2 this year just myself, not even going to the process. I get phone calls all the time because of my position in the union. I think I have a grievance. Well,
And I think
no,
that's
actually you
important
don't.
for.
There's a
I
lot
think
of-
that's
so there's a
important
lot
to
that
know.
stop.
Right.
Yeah, there's a lot of
So-
union members that think that every time something strikes them as unfair, that it must be a contract violation. Those are the
And that's not
ones
the
that
case.
stop.
And that's why we just wanna be educated, because there's a lot of work that you do behind the scenes that we just aren't aware of, and, we're not sure how it happens or how it works. So that's basically, it was just an inquiry to help us understand that
And
part of the
Roxy,
process.
real quickly, how does your disciplinary appeals procedure differ from ours?
Let me see,
I mean, what are the,
on section 2 authority, we went, I think we have the 90 days, which is also similar to yours. I'm gonna go through these and basically kind of check off and see which if it's basically the same and your language is simpler and easier to understand, we'll definitely work with that. But it was a change to 90 days on,
up to 90-day agreed suspension?
right, agree. I think most of the changes are the same kind of changes that y'all had made.
Okay.
On page 21, on section D, timing for disciplinary actions, Number one, I think we changed it to reflect what you had put in there. And I'm not saying we're declining all the other language, it's just, we're looking at the basic concepts and intentions right now. Some of the dates may be different, I don't have that right in front of me.
Well, dates I'll be able to figure out.
Yeah, the
pretty
dates,
easily.
but like substantive stuff. You had proposed, like on the transcript, that it wouldn't be shared with the arbitrator if we order, if we have it, but we have had cases where the arbitrator finds out that one of the parties orders it and then orders that we provide it to them no matter what, you know, so, those are the kind of issues that we're facing,
So
there.
I'm looking on page 22, that subsection F,
Mhm.
and you said there, if the parties will try to agree, if there's gonna be an official stenograph, parties trying to agree before the hearing. If there's no agreement, a party desiring to do so may have a transcript made at the party's sole expense.
Right.
I assume that would not be an official, transcription though, that would go to the arbitrator, or?
Well, the thing is, like, for instance, if we usually, just because of retention requirements and accountability standards that we have to be subject to as a municipality, most of the time, I think we have, requested a transcript. And when we get a transcript, we get a notary public, somebody who's used to somebody who takes court hearings, a certified stenographer who's a notary public, et cetera, who can certify everything. So it's something that is very, when we order a transcript, it's something that is basically reflects whatever happened at I don't know if we've agreed to take minutes. I think we've agreed that if we had a transcript, that would serve as the official transcript. One of the issues that happened on one arbitration was that we ordered the transcript and had our stenographer there, and obviously the arbitrator saw her there and basically said, "You're gonna give me a copy of the transcript." So we really didn't have a choice. It was ordered by the arbitrator, and it was within his purview at that point. So, when we don't have, a secretary just sitting there typing it out. We always hire, and maybe we
A
need
court
to,
reporter.
right, and maybe we need to specify that in there. I know they're expensive.
Yeah,
but-
because I don't think the arbitrator has that authority to order you to give them a transcript if the parties haven't agreed it's official record of the hearing. And I would have challenged the arbitrator on that, but,
Both parties
that's just me.
agreed at the time,
Yeah.
once he ordered.
Well,
it,
one,
so
yeah, I
sure,
mean, if
you
they
know.
want it, nobody wants to take off the arbitrator.
That's right, it's kind of you're kind of captive at that point.
Yeah. Let me ask you about one thing on page 19. This union fees and expenses for representation, I know that is in the current agreement, but I just don't see how we can leave that in there.
Okay,
I mean, I want you to understand, I'm not just saying that because the union has a duty of fair representation.
Okay,
And if we treat a non-member different from a member, we have to have a rational, non-discriminatory reason for doing so.
okay.
So just the way this reads, it sounds like, we're gonna treat non-members differently.
Right, and that's not the intent, and the
I didn't
reason,
think
the
so.
reason I left it in there, I noticed that you didn't put it in there, but the reason I left it in there is because the city does not intend in any way to take away any right you have to this. And so if you're saying that you don't need it because, and you can take care of it another way, then we're agreeable to that. But the
Okay.
only reason I wanted to have this discussion, and that's why I left it in there, because I just didn't want, if it's something that needs to be in there in order to retain your right to be able to recoup your expenses and costs, we weren't interested in taking that away from you, okay? So that's why
got
that
you.
was there.
Okay.
And I think that's also present in the the disciplinary appeal procedure too, so.
And then finally, was there anything about the discipline, else about the discipline you want to tell me about?
I was looking at these notes, give me a section, You had put in there something about an investigation, it wasn't in the old contract, we didn't put it in there, but I'd like to talk about, you know,
Okay.
when we get there, your reasoning for an investigation, et cetera.
I'll find it when I compare our two proposals.
Right.
So, and
But
I'll
basically,
be
I think it
prepared to
was
talk
just the
about it.
time. Time stuff, and we added in the discovery, the same kind of discovery provisions and witness list provisions that we included in the grievance procedure.
Okay.
You know, the ability to exchange documents ahead of time, because if there was a document we didn't know about and we need to see it before the well before the arbitration, it may change the whole game, or the whole situation, and I think that's something that would, be conducive to resolution if appropriate.
Okay.
And then I left in that, same thing about the union charging non-members a reasonable fee, and we're fine with taking that out, I just didn't want, to take away that right if we needed it.
Yeah, you know, and the difference in grievances and disciplinary appeals is whereas we clearly have a gatekeeper function on grievances, disciplinary appeal, whether to appeal a disciplinary suspension, is absolutely the members are, and by member I mean bargaining unit member, their choice. You know, if you fire somebody and we think they don't have a dog's chance in hell of winning that, they still get to make that decision.
Whether they're a union member or not, correct?
Whether, yeah,
Right.
bargaining unit member, anybody, I mean, you know, and so, all the yahoos are not on my grievance committee on this bargaining. Oh,
Thanks, Craig.
I wanna be there for you, man.
Thank you, buddy.
But, you know, for that reason, I know I'm gonna wanna take it out there too. I mean, every decision we make about funding or not funding a particular grievance or disciplinary appeal has to be made on a non-discriminatory basis. And, so we're just real cautious about putting language in there that might indicate in any way we're making decisions based on membership or non-membership.
Okay.
I mean, that's why I took it out.
Okay, and if, I think those are the, you know, timelines and the discovery, if there's another change, I'll be sure, you know, I'm sure you'll either catch it or I'll bring it up when we come
Okay.
back.
And tell me about your zipper clause. Do we have a zipper clause in the current?
We don't, but it's basically, you know, we have the management rights proposal, and then we have the zipper clause, which is kind of, I've seen them as kind of the two bookends of.
Well, actually, the bookends normally are a zipper clause and a maintenance of standards provision. You know, because if I've only glanced at it and I have to read it more carefully, but this looks like a really broad zipper clause. I mean, why don't you explain it to me? Well, I mean, what does it say? I mean,
Basically, this zipper clause is saying that the entire agreement is within the written, you know, these four corners of this contract. That we retain our management rights unless modified specifically, by this agreement. And anything that's not in this agreement is, not included in this agreement by design, like we didn't, you know, if we didn't bargain on something or we didn't agree on something, then it's not part of the collective bargaining agreement.
so if there was a memorandum of understanding that we entered into 5 years ago, unless we make it part of this agreement, it's dead.
Right,
Well, that would clear up the need for discovery, wouldn't it?
that's right, unless there's a new memorandum of understanding right after.
Okay. You know, I mean, I'm not, inherently opposed to zipper clauses. I mean, they're a common feature of most contracts, I agree. I do think that the maintenance of standards, is the bookend as opposed to management rights. I mean, management rights and zipper clause are all for management. And so, you know, they're not bookends. I mean, the bookend is for what preserves the union rights, and that's the maintenance of standards provision. So that's, you know, what I think we're gonna wanna do is look at those three issues all together. What's in management rights, what's in zipper, what's in maintenance and standards. And, the reason I was so interested last week when you talked about 30 maintenance and standards grievances is because that seemed like an astronomical number to me. And I thought, well, man, that is really a problem. But if in fact there are only 5 maintenance and standards and only 2 of them have gone to arbitration in the life of this contract, that's not unusual numbers.
But it's also referred to in, and I need to look at it.
You know,
I heard
and
the
maybe
number
quite frankly, they
17.
need to stop doing that sometimes because, I mean, we always want to throw maintenance and standards out there, sometimes, but,
The problem with
you want to use it as a knife as opposed to an axe or a bludgeon.
The problem that we have encountered with the prevailing rights clause that was in the last contract is that it was basically used as a catch-all to almost, as a catch-all to kind of say if it's not covered in the contract, then it's covered because this is something that we believe that we have the right to do.
And, and I think it's legitimate to say, well, if you file a maintenance and standards grievance, we want you to describe within the 4 walls of the grievance what is the particular practice that is the standard that you're trying to maintain. It's like you said, well, they pulled an MOU out at the arbitration. Well, that ought to be pulled out at the first step of the grievance procedure and say, hey, chief, have you forgotten about the MOU you signed 2 years ago?
It was chiefs before that, so.
Yeah,
it was
yeah. I mean, that's what's wrong with this whole contract that we got right now, is not that there's a maintenance and standards or any particular provision, but that it's just an amalgam of things that have been written over many, many years, and it's in places incomprehensible.
One of the other issues that I get concerned about with the maintenance and standards clause and the prevailing rights clause is that it can create unknown, unfunded liabilities the city doesn't budget for. And as you know, we're constitutionally required to adhere to certain, to have to budget for any liabilities that we may face. That's a concern that I have because, when you're talking about, I asked you to explain, give me examples of maintenance and standard. It may be a parking space. Well, what kind of cost is entailed with, making sure somebody, each firefighter has a parking space if we don't even have the space for that. And then if we go, under a maintenance and standards, we're required to build a whole new parking lot or something like that. Like you said, if they thought they were entitled to a TV, but we couldn't get a TV because of budgetary constraints, and then all of a sudden we're forced to get that, and we're forced to expend money that wasn't budgeted specifically for that. And those are just little examples that we have talked about, but you have to really think about what does it really mean. I think there has been a disconnect on both sides as to what the prevailing rights provision really meant. I don't know that anybody knew what it meant, quite frankly, but it may, we had the concern that it would create some sort of unfunded economic liability that the city will potentially be on the hook for and doesn't have the ability to budget for, and we would, it may be unconstitutional in that respect.
And the devil's in the details. I mean, when you talk about unfunded liabilities, I know you're talking about that Article 11, Section 5 of the Constitution, creation of a debt. But I don't think that is as broad as most cities understand it. I think that there is law out there that says that, in fact, normal obligations to employees are not debts within the meaning of the constitutional prohibition. But we're getting pretty far there. As I said, the devil is in the details. If you say, well, we need to throw maintenance and standards out because we're afraid of unfunded liabilities, I say, well, it's been in the contract since 1976. Has there ever been a situation in which ever the city lost a maintenance and standards grievance that created an unfunded liability? And if the answer is no, and I think you're gonna find the answer is no, then what's the problem we're trying to fix? You understand what I'm saying? I'm gonna look at these 5 maintenance standards grievances, but I mean, the maintenance is the one that I heard and that I think is causing all the furor is people wanting to voluntarily demote. And, that's a problem. I mean, it seems like all of our problems ultimately get back to that whole ambulance question. But, killing certain provisions of this contract aren't gonna help us deal with that underlying problem. And, so I'm gonna, be searching for something that, A, gives you the management rights language you feel you need, B, has some form of zipper, and C, has some form of maintenance standards that is a happy medium. I mean, to protect the legitimate interests of both parties. And if we can do that, that's gonna cure one of our big problems. And then the other big problem, of course, is ambulance. Oh, and that nitpicky stuff about compensation. We can finally turn and deal with that, which we're really interested in. So, okay. Well, let me go back with my folks and look at what you've given us. And I guess y'all are gonna keep working on proposals.
We're gonna keep working on proposals, and we're also going to compare what we've given to you so far and see, on language issues.
Okay. I'm
so
gonna.
we're working on that too.
Okay. And we'll keep you apprised of our progress. I hope to give you some counters a little bit later today. We're gonna go ahead and look at those right now.
Okay.
Okay. Very good. Very good. Okay, we've given you counter proposals on Article 1, 6, 14, and 22, and I want to go over those in a minute. While we were away from you on the break, we were also, I have 3 other proposals that are close to being ready on what is our Article 21, which is work schedules, Article 24, which is grievance procedure, and Article 25, which is disciplinary procedure. I say we're close to that. We actually have some draft language, but we're going over it, but we didn't want you guys out here cooling your heels too long. So maybe we can talk about this stuff and go back in there, time permitting, and maybe we can get you some more stuff today. Let me talk about Article 1. First, if nothing else, I would hope we could TA on this one today. I took your language from your February 20th proposal. I didn't substantively change it at all. I made it a little more clear. I did change union to association for reasons that we've discussed previously. I wouldn't think that would be a big deal to y'all, especially in light of the fact that all of my proposals for the entire contract are referred to us as the association. So why don't y'all look at that one and tell me whether or not you think you can agree to that.
I saw, the designation of the Unions Association, and the response that I got, because the union has been referred to as a union since the first collective bargaining agreement we've ever done here since the 70s. So I was just wondering why are they changing, why do they want to be now the association rather than the union?
Well, because we always have been the association. I mean, in the contract, we refer to it as the union, and I make no bones about the fact that we are a labor union.
Right.
But we're the Corpus Christi Firefighters Association.
Okay.
We are part of the International Association of Firefighters, AFL-CIO, CLC. And, we want to be referred to, when we talk amongst ourselves, we talk about being members of the association. So it's not a substantive change. It just really reflects kind of the way we know and see ourselves.
Okay. With regard to where you could also known as the International Association of Firefighters, AFL-CIO, CLC, we all here, most of us here at the table know what those acronyms are for. Would you be include that in the preamble, pursuant to how you identify yourselves. Would you be willing to include the meaning of that in the definitions or something? That way, if someone is looking at it, they know, they can go somewhere and say, what is the AFL-CIO CLC?
Yeah, I mean, hang on a sec, let me see what we've got in the definitions, right now.
I'm trying to keep a laundry list of things that we would like, that we're gonna need to include as we go through the proposals.
You know, what I've got is item 2 in our current definitions proposal, and I say association means the Corpus Christi Professional Firefighters Association, Local 936 of the International Association of Firefighters, AFL-CIO CLC. Are you saying you simply want to add to that the AFL is the American Federation of Labor, the CIO is the Congress of Industrial Organizations, and the CLC is the Canadian Labor Council, I think is what that stands for?
That's all.
Yeah, we'd be glad to
Okay.
add that to the definition.
So, and with regard to I do have questions on the addition, okay, on that next sentence, it says, the city and association agree that the intent of this agreement is to establish compensation, working hours, and conditions of employment. And then you added for the city's firefighters who are represented by the association. I just needed some clarity on that. Firefighters who are represented by the association, does that include non-members?
Yeah,
As well as
it's the bargaining unit members.
Okay.
Okay, and you know, you get to the preamble before you get to the definitions. I mean, we could just eliminate that who are represented by the association, and we could capitalize firefighters, because firefighters is in definitions as firefighter or employee means a bargaining unit employee covered by this agreement. So yes, it definitely is not limited to working conditions for members, it's members of the bargaining unit.
Right, okay. And
So-
I just wanted clarity for that, because it wasn't, we haven't established, I guess, if someone's reading this and they say who are represented by the association, there, you can make the automatical excuse me, my mouth is going faster than my brain is. You make the assumption, or you can make the inference that, if you're represented by the association, you're a member. So that was just the only.
You know, we could change that to
Just to make
working
it
hours and
clear.
conditions of employment for the cities, or just, and even eliminate the cities just for firefighters. And because in the definitions that's defined as the bargaining unit, then it would be clear. So I'd be glad to make that change.
Okay, well, we'll do, because I was working on that, I had those questions, I think that we can go back and, put some, you know.
You want me to change it up right now here and just
Well,
send it to you?
I need to visit with my, well, unfortunately, I'm not the one who makes the decision, the ultimate decision, so I do have to confer with my team.
Okay. But yeah, I mean, I can promise you that the changes that we've made are not substantive in nature. It is your, you know, it's your preamble.
Okay.
So.
Yeah, and as we're going through this, I know that we're, you know, when we're going through the proposals, sometimes I've tried to capitalize firefighter and keep it consistent throughout the, you know, our proposals as well as your proposals, but I think there were sometimes I didn't capitalize it, so I'm gonna try to be looking to correct those.
And
things
I've been
as well.
watching that myself.
And,
so.
if we're gonna define agreement as the collective bargaining agreement, then we, you know, we'll change that to agreement as well. So I'll work on getting that stuff, consolidated
Okay,
and consistent. Okay, so we'll go back and, we will, make our counter proposal and, see if we
Okay.
can get.
It'd be nice if we could get that one today, just so we can say we made some progress. It's been a long time since we actually TA'd on something.
Yeah.
Okay, that takes us on to Article 6, which is management rights. I took your management rights language and I incorporated it into ours. It would really help me, and I think streamline the process and quicken the pace, if y'all could take the articles that we've given you and make your changes to those articles. I promise you, I'm not trying to keep you from dealing with anything, but it's really a slow go for me to find out where you're coming from
Right.
with your And I can tell you that, subject to other verification, I think I've included everything that's in the contract in our proposals. And although we do have a March 5th deadline, I think you got everything from us you're gonna have, okay? But management rights, I'm gonna tell you that, this one is hard, for my team, because, you know, they've wanted to go over the laundry list of things that you have, put in your management rights and say, well, what does this mean? What does this give them? What, you know, what powers does this give them? And I have stressed to them the conversation that you and I had last week, and I think it behooves us to go over it again, that management rights really doesn't give you anything. That what it does is it allows you to retain the things that have not been taken away from you by the agreement or by state law.
That's right.
Well, or federal law.
Or
you know.
federal law, or any.
Or city.
Any
you know.
kind of legal legal limitation that tells us what we need to do.
Yeah,
But-
and I told them, I said, you know, you can go over those bullet points, and you can say, and all you need to know is that they have the right to do those things unless it's affected by the agreement or by law, but if it is affected by the agreement or by law, the specific provision of the agreement
Prevails.
or the state statute, as the case may be, prevails.
That's right.
And so, you know, to make that clear, I've been very clear about talking about rights that are retained. And you might say, well, given your explanation, Craig, why did you eliminate any of the bullet points? Mostly, it's duplication. If you'll look at what used to be, I mean, your item 2, which I've left in, is to determine the organization and operations of the fire department. But then I've eliminated 5. And that's to exercise control and discretion over the organization and efficiency of operations of the fire department. And then I've eliminated 7, to manage the affairs of the fire department in all respects. I mean, you know, a lot of this, frankly, and this is not criticism, but you know, you're just saying the same things over and over again. And so I haven't, you know, there's a couple at the end that I've eliminated because to contract or subcontract out work or to use non-sworn personnel in any manner, I think to leave those in there would be misleading because I think the Civil Service Act so clearly, totally circumscribes your ability to contract out firefighter work and to use non-sworn personnel to do firefighter work. So those are not duplicative, and I did eliminate those, but because I just think that that's misleading. You know, you still got a list of, I don't know, 17, 18 things in there that I think are pretty broad. And as long as we both understand that this is a retention as opposed to a gain, you know, a gain of additional powers you didn't have before the contract, then I think we're fine, and I would hope that we could come to agreement, something along the lines of what I proposed here. I did put back in the language to, you know, indicate that we're not trying to, because the way you had it worded, it looked to me like y'all were trying to disqualify the Civil Service Act and other statutes, and I know you said you weren't doing
Right,
that
that's not-
last week, and so I put the law stuff back in there.
Yeah, just to cover what we intended by this management rights issue, as I had said before, we just wanted for everybody to understand the rights that we have in order to make these management decisions that aren't within this collective bargaining agreement that we're bargaining right now. If there's a specific or express provision that modifies our management rights or binds us to, you know, to do something specific, then that's what prevails in the collective bargaining agreement. But if it's not touched in the collective bargaining agreement, then we retain that right already. You know, it's not something that we're gaining. We're just making sure, and some of it may seem duplicative, but out of an abundance of caution and out of the history with regards to prevailing rights and grievances and in relation to management decisions that have been made, we just felt that it needed to be clear and outlined and specified, and that so you and understand what we understand our management rights and authority to be.
Well-
And of course, it is limited by the specific provisions of the collective bargaining agreement and any laws, whether it be federal law, state law, Civil Service Act, ordinances, anything, any local laws, things like that. So,
And frankly, I mean, the things I've eliminated, for the most part, are really just duplicative and make what you have written, when you look at the 32 things that you have there, leaving them all in there makes it really unclear
Right,
what
okay.
you're even driving at. Because, determine the organization and operations of the fire department, and then, to manage the affairs of the fire department in all respects. When I look at those two things together and say, okay, those are different, how are they different? And then, item number 2, to determine the organization and operation of the fire department must obviously not mean what it says, because otherwise you sure wouldn't need to talk about to manage the affairs of the fire department in all respects.
we can work to consolidate it to cover,
Yeah, but-
what we intended to cover. The main concern I had was that I just wanted to make sure that, and I think you've explained this, but I just need to make it clear. As I understand it, the deletions that you have proposed are not because you think the union has that we're limited on those, management rights, but rather you just felt that they were duplicative. Is that correct?
That's right.
Okay.
The only thing that I said is an exception to that were your items 31 and 32.
To contract and
Yeah.
subcontract out. But we do have those rights limited by the law and I
As
guess.
it pertains to firefighters or the members of the bargaining unit, you really don't have any right to subcontract out work. Not only the Civil Service Act precludes you from doing that, but also there's a provision in the government code itself, in chapter 43 of the local government code that also precludes you from subcontracting out the work of firefighters.
Yeah, a
And-
work that would require a sworn firefighter.
Right,
Right,
and the
okay.
same, using non-sworn personnel, you say, use them in any manner. Well, as it pertains to firefighters, which is really what this contract is about, you don't have any right to use non-sworn personnel to do the work
Of sworn firefighters. But we-
unless we give you that right in the contract.
But we do
some of the
have the
stuff.
right to contract and subcontract out work that doesn't require a sworn firefighter.
Sure.
And we also retain the right to use non-sworn personnel for duties or positions that don't require a sworn firefighter.
Right.
So, okay. So
I
we
mean,
can
like,
clarify that. We
I-
can
I've
clarify
left,
that.
yeah, I've left some stuff in there to determine the organization and operations of city government. Well, outside the realm of the firefighters we represent, we don't have a dog in that hunt, unless it somehow affects us. So obviously, we don't care about, what subcontracting you do in public works or, something like
Well,
that.
and we did have a particular issue in grievance with regard to a community paramedicine program that was being funded and organized through the health department with the cooperation of the fire department, because they were trying to use that community paramedicine program to alleviate habitual 911 callers, people who are calling in to get rides to dialysis, people, things like that. So I think
And-
that's why it was important to the city, if we're trying to do something like that, and they're not emergency medical responders, they're basically caseworkers. That if a fire, the way, as I recall, if a firefighter was aware of a habitual 911 caller and it really wasn't an emergency medical response, but they were basically being called to transport or taken to the doctor, or or say I have a headache, things like that, they would refer that particular case to the community paramedicine program, and then they would be casework. They wouldn't be doing anything that a firefighter or somebody who a sworn firefighter that does fire or emergency medical service responses would do. So we had that issue, and that's why we think it's very important to make it clear that we have the ability to do that through another department and without.
On that one specific issue, you don't have that right, okay? Because if it's work that requires an ambulance, Your fire department provides
The- the-
ambulance
the
services.
program didn't require an
Yeah,
ambulance.
this program didn't require an ambulance. It was basically a case management program.
Okay.
So-
That's the kind of thing.
Through the health department.
You know, and if you're right about that, in the way you're describing it, if it really doesn't require a paramedic or an EMT or trained medical personnel,
It doesn't,
you know, and it
right.
doesn't, you know, then that's fine. But you use firefighters to transport people all the time, to the
Right, this would-
hospital, et cetera.
This would not be transport, it was basically, the program was case management with either a paramedic, a civilian paramedic, or an RN who does case management, medical management, that would refer them to services that would help them rather than them just automatically calling 911 and burdening the system, you know, with the habitual calls.
Okay, I don't know enough about that specific situation to, you know, I mean, what you're describing is a non-medical response.
Right.
And
I think
to,
there
to,
is.
to something that's initiated by the person as a medical call. They're calling 911, thinking they've got an emergency, and you decide based on some matrix that it's not, and we don't have to respond medically.
No, actually, no. It was not based on a 911 call. It was based on a referral from from firefighters who deal with this, you know, who are hands-on with these cases, and say, hey, we have this person calling 911 all the time, but we really think they need actual services that may be available to them that will help them get the services and the treatment and the case management they need. It wouldn't require transport, it wouldn't require, you know, it wouldn't prevent them from, if they call 911 from firefighters or emergency medical responders to respond, it wouldn't do any of that.
You know, man, that's so tricky. I mean, you know, firefighter comes and tells you, and we're getting sidetracked, I know, but firefighter comes and tells you, look, we've gotten 10 calls from this woman in the past month. Every time her husband falls and she can't help him up, she calls 911 and we send an ambulance out there, and all we're really doing is helping get the guy up off the floor. And you say, okay, that's not really a medical situation.
Or it could be.
Or it could be.
It could
And so
be,
every
and they do
time that
that.
call comes in, it has to be medically evaluated and determine whether or not she's just making another nuisance
No,
call
that's not
again, or,
No, that was, the program was separate and apart from the fire department operations. Completely separate, it needed the cooperation of the fire department in order to make the referrals, in order to know who they can offer these services to, but it was basically a community service, separate and apart from the fire department operations, that was funded and would be staffed by the health department. And it was just a health department attempt at getting a case manager to that person to see if there were other services that were available to these people that they just didn't know that they had access to. It wouldn't, they could still call 911, and
you
they would
know,
still
the
have
way
to
you're
respond.
describing
So-
it, I'm not understanding why, you know, except for firefighters making referrals to that system, I'm not understanding that as an emergency medical operation at all.
It's not. The community paramedicine wasn't, the community paramedicine program was not an emergency medical response program at all. It was a case management.
Well, then I'm not clear why you pulled the plug on it.
The problem was that it was a health department program that was going to be funded by a 115 waiver given by the state. The 115 waiver, I don't know if you're familiar with that, but it's a grant program where you put money into it, but you have to meet certain matrices and certain metrics, is what they call them, within a certain time period. And it's actually pretty quick. It has to be done, you know, each metric and matrix is done, I think, within a couple of months, a year. I can't remember the exact timing of them. But once they approve that program and it needs to start going in, I mean, things need to start happening immediately in order to meet that program. When that happened, and that funding is all, the health department or the health district is the only one who can apply for those funds and the only one who can receive those funds.
Okay.
a grievance was filed, which was challenging what we were trying to do and putting at risk the ability for us to meet those metrics, and be able to be reimbursed and get.
Okay, let me find out from my guys. I mean, what you described to me is not an emergency medical operation at all. It's not something that requires paramedics or EMTs, and therefore, if it doesn't require a paramedic or EMT, I don't know why we would be in the fire department rubric. But if my guys file a grievance about it, then there's something I don't know about it, or maybe that you're not describing. Or maybe they didn't understand.
Yeah, and there were some documents that were exchanged, and I think there was even a memorandum of understanding trying to explain to them what the program was, and so.
I mean, I remember something like this. I mean, my recollection was that MGT study that you had done right before the 2014 bargaining said that the contract had to be amended to do that, and that's what the connection was. But
I don't
if
know
that,
I
you know, if we just need to understand, I mean, I will say categorically that if it's something that requires an EMT or paramedic, and sometimes transports do, then that is fire department work. But if it's not, but if it doesn't require that level of response, then it's probably not fire department
Yeah.
work. And if it's a close question, we're negotiating a contract right now, we can certainly negotiate something so that you can do the community. You know, that's something I don't think we should try to handle through management rights. I think we ought to try and handle that through looking at the specific issue and dealing with it. Just give us a proposal.
What was the name of that waiver? I'll do some-
11:15.
It's 11:15.
I'm sorry, not 1:15, it's 11:15, I apologize.
No, it's 3:40.
It's an 11:15 waiver.
Yeah, but, you know, the thing about management rights language, and, you know, what happens invariably is that, and I've seen this so many times, that it's not funny. And that is that you negotiate a management rights provision, and then management comes to do a grievance and says, the management rights provision gives us the right to do that. See, right here it says we can determine the organization and operations of the fire department. Boom, it gives us that right. And they misdescribe it.
As long as it doesn't conflict with the provision
No.
of the contract or.
No, what they need to say is, we have that right, and we retained it because we didn't give it up in the contract.
Okay, I see where you're going.
You know, but they want to point to it and say, well, this management rights gives us this right. Well, no, it didn't give you anything.
We already
You
have
just
it.
retain inherent management rights that aren't otherwise affected by statute or law or the contract. And that's a given. I mean, if you didn't have management rights in the contract at all, that would still be true. I'm sure that'll come up in the next arbitration we do. That I said that. So, you know, so I see management rights clauses as really of limited utility, but I understand why management wants them, so that they can say, look, we've made it very clear that we're not giving up rights except the ones that we actually give up in the agreement. And I agree, you know, but at the same time, then they want to gunk it up by putting, you know, 50 things in there that they're specifically not giving up. And, you know, that implies that if it's not on your laundry list, you have given it up, which is not what you mean to do, but then that makes you want to add even more things. You know, so to me it's self-defeating. The more bullet points you have, the more you're saying, well, if we didn't get it in the bullet points, we've given it up.
Okay.
And I don't know that that's what you want to do, so I would urge you to keep your bullets to a minimum, but I do want you to feel comfortable that, you know, you're not giving up something you don't need to give up.
Okay, after the laundry list, we had a paragraph in there that stated those inherent managerial functions, prerogatives, and policy-making rights, whether listed above or not, which the city is not expressly modified or restricted by a specific provision of this written agreement, are not in any way directly or indirectly waived or subject to challenge. And I know you probably, that subject to challenge probably needs to be clarified in the limitations of the law that also needs to be clarified. But if you understand that's our intent, that we, you know, we're retaining these rights and we don't, unless we've expressly modified or given them up in the contract, that we don't waive them, why is that part deleted or?
You know, you essentially said the same thing twice. If you look immediately below that, what I've left, the city's exercise of its retained management rights and authority is not subject to challenge through the
Okay.
grievance procedure or any other form except when otherwise in conflict with a specific term of this agreement or other applicable law. I mean,
Okay.
you know, you know, I mean, I'm really trying to make it as simple as possible. I mean, I had a really simple one, and I understand why you added a bunch of numbered items, because if you look at every collective bargaining agreement in this state and probably in this country, they always have bullet points, you know. But I mean, I can go through everything in your laundry list and point you to laws that affect that right. I mean, you don't have one bullet point there that isn't affected by either the contract or some other law. I mean, to determine the organization and operations of the fire department, the Civil Service Act has all kinds of requirements with regards to that. To hire, examine, classify, promote, train, transfer, assign, and schedule. You know, I mean, hiring is, you know, promoting, you know, classifying, all of that is controlled by the Civil Service Act. Suspend, demote, discharge, take other disciplinary action, controlled by the Civil Service Act. I mean, you know, I mean, the important things you need to know about management rights, you get in basically the first sentence of your proposed language. If it's not modified by the agreement or law, you know, we retain all the management rights we have. So, you know, we're trying to rewrite this from the ground up, and I mean, my goal in every proposal I've given you and every counter I'm giving you is to try to make this thing something that a firefighter who's not trained like you and I are, or even like management personnel are, can read it and hopefully understand it.
Okay. I can appreciate that.
Yeah. I have a funny story in that regard. The city, I think it was Lubbock, but I may be wrong on my city, so I probably shouldn't mention names, but they were mad about the union asserting some kind of civil service right, and so they put the civil service statute on the promotional exam, or one of the promotional exams, and all these firefighters therefore read the statute for the first time, which resulted in a plethora of additional claims. And it never got put back in the promotional study materials again. Don't make firefighters read something. That's bad.
Okay, those are the questions I had there, and we'll work on
Okay.
and a counter proposal to that. Article 14, let's see, on uniforms, you countered with the 90. I think y'all had started at 100.
We had started at 100,
Okay.
and y'all stuck at 67, so we came down to 90. The thing that I want to the thing that I want to say about this is you know, I'm trying to show some movement. You know, these are small things, I admit. On mileage allowance in section 2. Yeah, I've got the wrong one. That's what's going on here. It would help if I get the right one. Yeah, we've come down to 90 from. We still think that 6750 isn't really getting us, you know, fully reimbursed. Rather than have some sort of, we've got so many other issues that are thorny, you know, now's not the time to do it. Obviously, some sort of a system where you reimburse for actual cost would, you know, be a preferable system, but, you know. On section 2, mileage allowance, we've essentially agreed to your proposal. We, you know, in the spirit of compromise, I asked my team how often have y'all used something other than the IRS rate, and in the history of the fire department that we're aware of from our experienced people, apparently only once. So we're assuming that there's not going to be, and we're also assuming in section 2 that obviously if you reduced it, it would be a citywide reduction. I think.
Yes, that's the
So
intention.
it would only be a citywide reduction.
Right, it wouldn't
Right.
be just required, it would be everybody
Everybody.
at the city would be affected.
So if it's that bad, they want to do their part. Section 7, legal defense of firefighters. I put a note there that, you know, this is the one I was talking about earlier, where y'all just really kind of, in your proposal, reiterated what is in the current contract, and it's almost unreadable. And so I reorganized it so that, again, a firefighter could look at it and kind of understand what his or her rights are, but at the same time, I represent to you that when you read my proposal, you're going to find that it doesn't change what the contract actually requires. So my proposal is essentially your proposal back at you, just in clearer language.
Yeah,
And it's part of the agreement that we made.
It's almost similar to the language in the old contract with just, you know, organized differently and bullet pointed. So I have been looking at that to see how we can meet in the middle on how to make it clear, and I was reviewing that, so.
Yeah, there was no
we'll work on
intent
it.
to change the city's obligation at
Okay.
all. I mean, it, you know, whatever the legal defense mechanism is that exists, it seems to be working. There are no complaints from our side. I'm just trying to make it, you know, cleaner. So, you know,
And at the same time, it's not our intent to take away anything, on the legal defense of firefighters either. So,
Right.
I think we're on the same page. We just need to work out the.
oh, and the same
language.
thing, I skipped over section 3, meals. We went to you'd offered 8, we agreed to accept the 8. So, you know, I really think that, you know, your proposals so far haven't really dealt with sections 4 to 7 of my proposed Article 14, but again, we were just incorporating provisions of the current contract without changing them substantively. So I would think with the changes that we've made now, this is one where we might be able to do a TA. Obviously, y'all need to look at sections 4 through 7 to see if there's something in the current contract that you don't like, and if so, obviously, I just ask you to make us a counter.
Okay. Before you move on, if we TA a certain, if we can TA a certain section, do you want to TA a section,
No,
or do you wanna do the entire thing?
Let's try and do the entire article. You know, I think that'll make it simpler for us. And the thing that I would say is remind you, and I think our ground rules make this clear too, your TAing on an article doesn't mean that you've agreed to it unless and until we reach agreement on the entire agreement. And your agreement, and it doesn't even preclude you from opening it back up if, when we're talking about a different topic, it raises issues in this topic that we hadn't thought of at the time. So in other words, you know, even if you TA on 14, it's hopefully out of the way, but you can always raise it back up if something else happens. So you're not really endangering yourselves by TAing on something. I mean, I've been talking about that with my team too. You know, well, what if we TA on management rights before we get to, you know, this maintenance of standards? We don't know what they're going to do on maintenance of standards. Well, until we have an agreement on everything, we don't have an agreement.
Right,
So-
and, you know, one proposal that somehow, you know, modifies our management rights will absolutely affect, you know, if, whether we need to change the management rights or not, if it's not clear, so, yeah, I understand.
Okay.
While we're on, okay, on relief, on section 4 relief, I know this is something that has appeared in the contract, but is this something in, I don't have, I'm asking this question out loud because I just don't know and I haven't asked, my team, but is this something that is part of a standard or procedure or protocol or something that's already in effect other than here in the collective bargaining agreement?
Yeah, yes, I mean, it's a safety provision, and I think that you would find that, you know, in terms of how they teach firefighting, that it's in line with those kinds of things, that, you know, there's a fatigue factor that sets in, and the deputy chief's not here today, I know, but I think he would agree with me that this is, you know, it becomes a safety issue, you know, as you become fatigued, just as in other areas of life, judgment becomes a little bit impaired, et cetera.
For instance, if the chief wanted to lower the threshold on the relief provision from 8 hours to 6 hours, that would be, we'd be stuck to the 8 hours by the contract?
No, obviously, whenever the chief wants to do more, I mean, you know, this section provides a floor. You know, I mean, if they've been there more than 8 hours, you know, the contract requires that they be provided some form of relief.
Okay.
However, you know, I think that you have to interpret the relief provision using a rule of reason. In an emergency situation, you know, sometimes all bets are off. You know, a couple of years ago in Austin, we had simultaneously a fire in Steiner Ranch on the west and a fire in Bastrop on the east, and literally every firefighter was pulled into service for an extended period because they needed every available person. This is just generally, you know, I mean, just, you know, in a major, you know, if it's the Chicago fire, you know.
Yeah, it's not like an extenuous or
Yeah.
emergency situation.
Yeah, you know, in an emergency situation, you know, you gotta do what you gotta do, I mean, and firefighters live for those kinds of situations, so they certainly understand that. But in practice, I mean, if you look at your SOPs, et cetera, you're gonna find that this is pretty much the way they do it. I mean, we're not really.
Section 6 on the assignment, I don't think we went through these, that's why I'm asking the questions out, specifically. Section 6, the assignment preference forms, this is just for any firefighter who would like to apply for a preferred position, and it's at the chief's discretion, is that
Mhm.
right? Okay.
Yeah, I mean, you know, the fire chief is making a commitment to consider taking assignment forms, but, you can see that in the list of factors that the chief considers, the number one listed is the needs of the department. And then, you know, and section 7 kind of dovetails in with section 6.
Yeah, I needed a
And-
little bit more clarity on that.
You know, it describes the system that currently is in use in the fire department, and whereas it reads a little bit, you know, you and I can read it and understand it, I'm not suggesting that, but the firefighters are all pretty familiar with the system, and I think the deputy chief will tell you that it's, you know, a system that's working well right now.
One of the things I did have a question on, this is well, it limits only for firefighter 1 rank, the seniority bid position will be used only to fill positions in non-ambulance stations. But other than that, the seniority bid, can apply to stations with ambulances, is that correct?
Mm-hmm.
So,
Well, but look at that, paragraph, section 7B, as in boy. No more than 2 firefighter, 2 EMS positions in each station are filled by use of the bid procedure.
okay,
So,
but what I guess what I'm
If the station has
asking-
more than 2, then the seniority bid procedure wouldn't apply.
This is the question that I'm leading to. If we have somebody who has chosen and bid for an EMS station that is slower than, it's one of the slowest or has a slower emergency medical response calls, et cetera, ambulance calls, are these people, the firefighters that are assigned to that and get it through this seniority bidding system, do we have the ability to transfer them out to relieve other firefighters and hire in fire stations with the ambulances that have a higher frequency of calls?
I don't think, I think the answer to your question is no. Once you've got a station assignment that you're happy with, I think you generally get to keep that station assignment. You can't, once you bid into a position though, you can't bid for, 3 years thereafter or something
Yeah.
like that?
So basically, what I'm getting to is, I'm trying to get this clear in my head. This provision, with the seniority bidding system and getting an assignment by seniority, limits the fire chief's ability to rotate people on ambulance duty throughout all stations. Is that correct?
I think the answer to that question is yes, that the chief doesn't generally just transfer a lot of people. That would be kind of a nightmare anyway. You got rotating, shuffling people and nobody knows where they're at and that sort of thing. That would be difficult. Because remember that it's not just simply a matter of moving people from one station to the other. When you move from one station to another, you have to learn a whole new territory. The firefighters have tests, that they take about the streets in their districts, and they're required to have a certain amount of knowledge. So every time you transfer somebody, there's a whole learning process that has to go on.
Okay.
So it's kind of self-defeating for the fire department to be rotating people a lot because, time is of an essence,
Right.
especially in the emergency medical biz.
Well, and I think this leads into the ambulance duty conversation we were having earlier because, we can't, I understand that it would not serve the purpose to be transferring firefighters on ambulance duty just to any kind of station, but say for instance, if we had somebody assigned to a very a heavy station with lots and lots of ambulance calls and they're riding the ambulance, like Steve was saying, he was riding the ambulance 9-10 times and it's all day long, he doesn't, 24 hours, the entire shift. If the fire chief had the ability to transfer Steve out to one other specific station that he was already familiar with, that if he got transferred out to get relief, a slower station, and it would always be that station in order to ease the burden, and so he wouldn't have to ride the ambulance so often. Wouldn't that kind of help with the ambulance duty issue and the people riding the ambulance so much?
We'd have to look at the specifics to know the answer to that question. I'm not thinking that it would help much, but if the chief were to say that he thinks it would help, I'd want to hear from him and why he thinks that might help. You're gonna have a drop-off in response times every time you move somebody. And that's a concern. And I think that also, I'm certain that there are areas of the city that have heavier call volumes than other areas. But even in the slow call volume, when you're getting called out at all hours of the day and night, it's not, it's not that you're in a higher pay station and a slower pay station, it's the nature of the duty itself. People who are on ambulance generally don't get much opportunity to sleep for a full 24 hours, and that just takes a toll. I mean, it's, not well.
And currently they have the 24 on, 48 off, and then 24 on, and then what's after that?
48 on.
It's 48 every time? Okay.
Yeah, they work 24 out of every 72 hours.
Mhm.
The exception to that is once each quarter they get a Kelly day, and that's a shift they would otherwise work that they get off.
That they get off. And that would be, when you're talking about quarters, you're talking about months?
Yeah, 3
Okay.
months.
3
Every
months.
calendar quarter,
Okay,
they get one Kelly day.
okay.
And
Well,
the
you know-
purpose of the Kelly day is not really to relieve them, it's to reduce the city's overtime.
It's
burden.
to bridge that gap, I think.
Between 56 hours, if you work 24 hours on, 48 off, over the course of a year, you'll average a 56-hour work week. And the FLSA requires overtime for everything over 53.
Right.
And so it's to help them balance that gap.
Okay.
Which reminds me of something else. It's in the current contract, and you've got it in your proposals, that we have an average 54-hour work week.
Yeah, I
And
did
I've
want to
tried-
talk about that.
I've tried every way I can, and there's no way that y'all have a 54-hour average work week. I mean, the Kelly days take 96 hours out of it, but if you do the math, divide 3 into 365, come up with a number, multiply that by 24, and then subtract 96, and then divide that by 52, you're not going to come up with 54. So, and I've tried every which way I can to figure out how they came up with that 54, and that's why I've left it out of my.
It's been in there for, I didn't want to take away from that, but I didn't understand it either, and I'm glad I wasn't the only one, so.
That's why I left it out of my proposals, but
Okay.
I understand that the Kelly day.
Because of that very issue, because
Yeah.
I didn't know if we would be taking something away, or what the implication was. So I guess we really do need to look at that a little bit more closely and have another conversation on that 54-hour average work week.
Yeah, I mean, neither one of our proposals are talking about changing the current system, so.
Okay. But yeah, that 54 kind of threw me off, and I couldn't figure, I didn't get it either, so. Okay.
They're doing the math over here.
What about 52?
Huh?
55.3, right?
Is that about 52?
Yeah, that's what I came up with, 55.6, so.
Divided by 3.
Maybe they were using, maybe at some point in the past, they gave more Kelly days or something?
They used a different calculator.
Maybe it's a typo.
Could be.
Batteries were low in that.
Yeah.
Like
It's
like
really
everything
solar
else,
solar
once
calculation.
once it got in there, it wasn't coming out.
Yeah. Okay. Okay, I think those are all the questions I had on Article 14.
Okay,
You want me to
what,
explain it to you?
yeah, what Johnny's telling me is that even in the slow stations, the amount of time that ambulances are out of service is relatively the same. And so it's not going to alleviate your problem
I might
very
could
much.
explain it a little better. In a busy station, that guys are averaging, let's just say 20 calls. I don't know what the real number is, but
Close.
it's close. In your slower stations, which I think there are probably 3, they're probably averaging 8 to 10 calls. The problem is because they're in the outlying parts of the city, they're out of service time, I guess is what you would call it, that they're on a call.
Calls take longer?
Oh, yeah.
Okay.
My station, for example, station number 2, when my guys get an ambulance call, the same type of call they would get at station 10 or station 8 or station 14, which are the busiest units in town. Station 3 is our busiest. That call will take them about 45 minutes. Station number 2, station number 13, station number 15, that call actually takes them about an hour and 20 minutes. That's probably the gap, somewhere in there.
Travel time. Like
It includes everything, it includes work.
Yeah.
So, I think I may be out of line, but I think this department has what's called a unit utilization number.
Mm-hmm.
Would that be possible?
We could get that information.
Yeah, and that'll show you if there's really a significant decrease in the utilization numbers.
Mm-hmm.
Because it's not just a matter of calls, then it's a matter of time. Because service time, you know, is traveling from the station to the scene, to the hospital, restocking, and then coming back. So-
And I'll make one suggestion. There's kind of a discrepancy when, and I'm just going to use Medic 2 because that's who I'm familiar with. That's my crew. It's not so much the time they go back in service as much as it is the time they're back in their service district. Now, I don't know if that makes sense to you, but when they're at Bay Area, my station's at 5 Points, by the way, Highway 77 and Up River Road. When they go back in service at Bay Area, it's a 25-minute drive from the hospital back to our territory. They're not available, well, I'll take that back. They are available to make a call in our territory, but their times are greatly increased because of the travel time. So, and I don't know if y'all break it down like that, Chief.
Isn't that why you have move out?
We don't have move-ups. Not to my station.
They are the
We
We
are
are
the
the
move-up.
move-up station. Our station moves into town.
Yeah.
You have to move Orange Grove to their station to cover it.
So anyway, I don't know how you do that, but they're really not back in service until they hit about Clarkwood Road, which is probably 20 minutes from the hospital. And not that that matters, I don't think, but you know, that's a factor to consider too. So, but it would be nice to have that utilization number.
Okay, but the slower stations are receiving half the calls that the busy stations are, you're just saying it takes longer.
This is what I would imagine, and I don't know because I haven't done the numbers, mainly because I don't know the UT utilization numbers, but although a unit in town is making 20 calls and spending 16, 17 hours, 18 hours of work, I would imagine that the outlying stations, mainly Medic 13 and Medic 2, although they're only making 10 or 12 calls, I would imagine they're probably still spending the 17 or 18 hours of work. They're probably one
And
of
a
the
lot of
same.
it is because of it's
Travel.
just travel.
Yeah.
It takes
Yeah.
longer and it's a lot
Mhm.
longer travel time.
Right, and
Okay.
what it comes back to is the sleep deprivation, the the stressors and stuff like that. So, and I'm not trying to discount what happens in town at all, but it's not like it's a walk in the park.
Yeah, 20 years ago, I'd say probably we had 3, what we call busy ambulances, and you probably had 3 slow ambulances. We don't have slow ambulances anymore. We just have ambulances that aren't as busy as top 10 in the nation. But we still have busy ambulances all over
Yeah,
the place.
we'll get the information so we have the data.
Okey-doke.
All right, moving on to your Article 22 counter proposal. The only change I saw in that was just, you crossed out EMTB and EMTI and just left it EMT, is that correct?
Yeah, and I wanted to, I actually looked at your alternate hiring procedure proposal, and it was the current contract language with 2 additions only. And
Bless you.
so, in other words, y'all's proposal on alternate hiring was, hang on a second, I'm getting to it. I did a comparison of the current contract language and the alternate hiring that y'all came up with. And you added 2 sentences, which is, you added a sentence in the first paragraph that reads, "The provision of this section also does not limit the chief to declare any vacancies at his discretion," which I wasn't sure what that meant.
Which paragraph is that?
I'm looking at the very first paragraph under alternate hiring.
Mhm.
It's the second sentence.
Oh, okay.
The provision of this section also does not limit the chief to declare any vacancies at his discretion. I didn't understand what that meant or how that added to the paragraph. And then the only other thing was in the second paragraph, under alternative hiring program, y'all had added the language, and maintain a paramedic certification. Each applicant must have and maintain a paramedic certification. And I wanted to point out that in our proposal was meant to be the current alternative hiring proposal, just reworded to make it clearer. With one exception, we allowed the chief to pick up people through alternative hiring who only had an EMT. And the reason for that was that sometimes it's better to put them through your specific paramedic program because you have such a high class operation. But by the same token, under alternative hiring, the chief has the discretion to decide, well, I'm only going to get paramedics. In other words, we're giving the chief more discretion, but we're not limiting his discretion to limit it to paramedics. So because I only saw those two changes, I didn't really make any changes to our proposal. Because our proposal, the reason I made the change EMTI or EMTB, those distinctions are that they're both considered EMTs. So I'm just trying to give the chief flexibility to do EMTs or paramedics at his or her discretion.
Okay.
And but other than that, our alternate hiring proposal is basically captures, I think, all of the discretion that the chief has currently. And I didn't see your proposal when I really examined it to change that in any way. So that's why I kind of reiterated that same language back to you. I don't think there's a whit of difference in our proposal unless there's something about that one sentence, again, that I'm not understanding that was added to the first paragraph. So, you know, the standard hiring process, the only other things in my Article 22 are just the standard hiring process, which again I think captures the current practice, and the probationary period, which captures both the current contract language, and I think it also addresses something that was in a proposal that the city made to us last year. So,
and that was on the probationary period?
Yeah.
Oh, yeah.
I'm not remembering off the top of my head if I made any substantive changes, but I'm not recalling them if I did. But, you know, this is another one where I think we could probably get agreement pretty quickly because it's not one that I think is controversial. It retains for the chief all of the authority that the chief currently has,
Okay.
as far as I know. You know, I remember the substantive change from the current contract is, the current contract has a provision for extending the 18-month period, and y'all eliminated that in your proposal, and so we picked up your proposal. So we just basically, the only change we made to the current contract language was something that y'all requested. So this is another one that I would think and hope that we could maybe get relatively good agreement on. And I'm just guessing from my side, obviously y'all have to look at it.
Yeah, we have to look at it, and I need to talk with certain people, make sure it's approved through the channels that I need to go through.
What Johnny's telling me is the stuff we're requesting is what the city refers to as UHUs. We have some statistical information but ours is old. This is back from 2004.
Okay.
But I think they still call it UHUs.
If I may, the updated version is on our website.
It is?
Yeah, the latest version, our number.
Unit hourly utilization.
Utilization.
Yes, based on 8,000 some odd hours that the unit is actually available in a year, and then we take the number that's actually out of service, and then we come up with a number. The benchmark is $8,700
A year?
a year.
Tired just thinking.
And that's, hey chief, that's our webpage?
Yes, sir. If
The
you go-
fire?
It's Corpus Christi Fire
Yeah.
Department, you look on it, it's posted there.
That's the .org one, right?
Roxy, unless y'all have other questions about the proposals that we've made, I'd like to propose that we go into our respective caucuses for the balance of the day. I think I'm close to having 3 more counters for you to the that you gave us this morning.
Okay.
We were working on counters to what is our Article 21, which is the work schedule. And I think we're very close to agreement there. And we're also still in conversation. We have draft language on counters to your grievance procedure and your disciplinary procedure. But we may need to do a little more vetting of that before we're ready to go with that.
Before we go to caucus, I just wanted to go over, we had mentioned earlier that you had emailed me yesterday with about 6 questions on some information that you were requesting. During the caucus, I was able to obtain all of that information, and I forwarded it to you in writing so that you have it on the email. I just wanted to go over that very quickly.
Okay.
Number 1, you asked, what is the city's contribution to firefighter employee-only insurance? The city contributes $296.98 biweekly, or $643.46 monthly per firefighter for employee-only health insurance. Number 2, what percentage does the city contribute to the firefighter pension fund for each firefighter? The city contributes 20.78% for retirement plus 1.45% to Medicare, which equals a total of 22.23% total for each firefighter. And that percentage is, that's the percentage based on what their wages, what their wages. Number 3, what is the city's contribution to police department employee-only insurance? The city contributes $225.13 biweekly, or $487.78 monthly per police officer for employee-only health insurance. Number 4, what percentage does the city contribute to police pension fund for each police officer? The city contributes 12% for each police officer.
You do not contribute to Medicare?
It's just 12%, as I understand it, to Medicare.
12% into their retirement pension fund.
Yes.
But you don't contribute to Medicare for police?
I couldn't say that we contribute anything to Medicare, but that's not part of their retirement.
You asked for the question.
Yeah, the question was what percentage does the city contribute to police pension fund for each police officer?
I know, I asked the same question for firefighters though, and you added Medicare to firefighters but not to police. And I was just, and I assumed from your answers that meant you didn't contribute Medicare for police.
I'll double check on that.
And while you're doing that, my understanding is that y'all also make a Social Security contribution for police? So, and that would be what, 6% or something like that?
I have to look at that, I don't have that.
So, I'm not,
I understand.
the only reason I just want to compare apples to apples.
Sure, I understand, and I'll clear that part up.
Okay.
Number 5, what is the city's contribution to non-public safety employee-only insurance? The city contributes $171.14 biweekly, or $370.80 monthly per general employee for employee-only health insurance. And number 6, what percentage does the city contribute to Social Security and Medicare for each non-public safety employee? The city contributes 6.2% Social Security and 1.45% Medicare for each general employee. So I need to find, you're
Okay,
also
and
looking
then-
to see if there's any Medicare contribution or Social Security contribution for fire.
Okay.
and
Yeah, what we're looking
Social
for,
Security for police.
for item number 4,
in addition to the police pension, do you also do Social Security and Medicare for them? And if so, at what percentage?
For the police?
Right. And then item number 6, although I didn't ask for it, I would like to know what the city contributes to TMRS for non-public safety employees. The information I have right now from January 2012 is 14.8%, in addition to the 6.2 and the 1.45.
On number 6, with regard to the general employees, I need to look at that. For some reason, I recall the 12% number, but I'll have to, of course, the number's gonna speak for itself.
That's the formula, but the actual is a little different.
Okay.
So we have to verify that.
Okay. Yeah, and I could have been a little clearer in my requests. But obviously, I just want to know, like, what I meant was, what's the total pension type contribution for fire, what's the total pension type contribution for police, and what's the total pension type contribution for non-public safety? So, you know, in keeping with the spirit of trying to get this deal done and done quickly, I think that as we push through March, we ought to possibly look at doing some double days, you know, instead of just doing one day, do 2 days back to back for some of the March day and early April days. I just, you know, I mean, I want us to, the pace is just a little slower, and I'm not casting stones, believe me, but the pace is a little slower than what I'd hoped, and I want to make sure that we give this our absolute best efforts.
I understand. Yeah, but one of the things I did for sure want to establish is that we at least had at least one meeting a week set up.
Right.
And then we can add to that as we move forward.
I'm just having so much fun with these guys that I just, I got to get here more often.
Craig, so after the caucus, what do you anticipate? Because I've got a baby I got to pick up before they kick her to the curb.
Oh, I'm not suggesting that we're going to have another. That's tough love. They get used to it. It makes for good stories when they come up.
Well, I hope.
And then Mommy didn't come get us.
Right.
I'm not thinking we'll get together in general session. I just, you know, they kind of shoo us out of here at 5 o'clock anyway. So,
Yeah, I think that's really only on Fridays. I
Okay.
think during the weekdays they have night classes, so we have, I'm kind of glad we haven't set something on Friday, because just keep in mind, if we set something on Friday, we may want to start earlier or something, especially if we're going to be dealing with the 5 o'clock kick-out time.
Okay.
But my understanding is that during the weekdays, they have night classes, and so that most likely shouldn't be an issue. I'll try to find out.
Let me just tell you, in looking at my calendar real quick, the weeks that I think the week of March, we're set on March the 26th. That would be a week that I could maybe do a double session, either on Thursday and Friday or Wednesday and Thursday.
So you would want to add either a Wednesday or a Friday on that one?
Mm-hmm.
Okay.
And the same, because. What the heck? Also, the week of April the 2nd, we have a meeting. That might be a good one for a double session. That Wednesday, the 1st.
April Fool's Day?
Hey, I'm with these guys. It makes total sense. And don't take it personally, guys.
No, we went last time.
So if we TA anything on that, we're really gonna have to say, are you sure?
You'll want it in writing.
That's right.
And you know, the week of April the 9th, I've asked y'all to consider moving that April 9th session to the 8th. But what we could do is meet on the 8th and then meet for half a day on the 9th.
Okay.
I think I could grab an afternoon flight out of here where did I say? Yeah, Love it.
Oh, and on that note, I have all the dates that we have talked about, not the additions that we're talking about, but we have confirmed with Del Mar that we have rooms reserved, and I think these specific rooms
Okay.
reserved. So if we want to add those dates, I'll have to check on our availability. I don't think that should be a problem, and then I'll check with Del Mar and follow up with that.
Okay, okay. Okay, so we're looking at maybe adding March 25th, March the 1st, and if we are.
April 1st, you mean?
April 1st, I mean, and then if we're able to
Half
meet
day.
on the 8th, do a half day on the 9th.
Yeah, we're booked, I think we're confirmed for the 8th.
Okay. Oh, we are?
Yeah.
Good, let me.
So all the dates that we talked about this morning are confirmed. Wednesday, March 11th, Thursday, March 26th, Thursday, April 2nd, and Wednesday, April 8th.
Right.
And then I'll check on Wednesday, March 25th, and Wednesday, April 1st, and then half a day, April 9th, which I think is a Thursday.
Okay, my calendar is looking pretty ugly. So, okay. Very good, guys. We appreciate it as always. And
Okay.
see you
Thank you.
next week.
Okay, thank you very much.